Okay, so we'll go ahead and open the meeting of the Northampton Zoning Board of Appeals. Um, First, I'll note for the record that this meeting is being recorded, uh, and that the members of the board, the full members, are myself, David Bloomberg, Elizabeth Silver, and Maureen Scanlon. The alternate members are Irvin and Sherry Taylor. The three voting members will be myself, Maureen, and Elizabeth. But as always, we welcome the full input of all members, including the alternate members. Um, Notice of this hearing was published on June 12th and June 19th, 2025. Um, and before we uh, hear the appeal, that is the only item on tonight's agenda, we always open by inviting members of the public uh, to address the board about matters other than the one that is on the agenda for tonight, other than 74 Coles Meadow Road. So, with that qualification, I'll ask, are there any members of the public here who are here to address comments or questions to the board other than in connection with the pending matter relating to 74 Coles Meadow Road?
And
Yeah.
David, I'll just add, yeah, you can raise your virtual hand, click the react button and click raise hand if you have other comments.
Okay. I assume we see none, Nathan.
No, I don't see any raised hands.
So seeing none, we'll move on to the agenda item. As I said, notice of this hearing for the appeal of the building commissioner's approval decisions for a residential mental health program at 74 Coles Meadow Road, map ID 13-001, submitted by Alexandra Glover, was published on June 12th and June 19th, 2025, and August 7th for the second application. There are two applications before us, identified in the city's records as LU-25-8 and LU-25-17. Procedurally, application LU-25-8 was opened without deliberation on June 26th, 2025, and continued to this date. And application LU-25-17 uh, is being heard for the first time today. Um, this is an appeal of alleging that an error on the part of the building commissioner, who I believe I saw is with us tonight. Yes. And in order for the Zoning Board of Appeals to overturn a decision of the building inspector based on a finding of error, uh, that requires a supermajority vote, in this case, a unanimous vote of all three full members, myself, Elizabeth, and Maureen Scanlon, in favor of overturning the decision of the building inspector. Um, and for this purpose of tonight's hearing, we will first hear from the applicant. In this case, it's Attorney Glover, who represents certain abutting property owners. Uh, After we hear Attorney Glover's presentation, we will have an opportunity for board members to address any questions we have to Attorney Glover. After the board has had an opportunity to do that, um, the board, I would anticipate, may have some questions for the attorney for the owner of 74 Coles Meadow Road, who is present. Um, and after the board has had an opportunity to hear from Attorney Tyne, um, members of the public who are present will have an opportunity to uh, address the board. I would ask that everyone who speaks on the record first identify yourself, name and address, please, for the record that's being kept, and that everybody who speaks addresses their questions and comments to the board, not to the applicant, not to each other. And to the extent reasonably possible, I would ask, although everybody will be given a reasonable opportunity to speak, that we at least try to avoid uh, excessive repetition of points that have already been made. But that having been said, people will have an opportunity to address the board with their comments, questions, and concerns. So with that as preface, I think
Dave,
question, Elizabeth. Yes, please.
a couple of things, just two quick things. Sorry to interrupt at this point, but I think the building commissioner that made the decision on this is not. Oh, did you actually do that, Mr. Hasbrook? That's what I was saying, that he is not the building commissioner on this that we're looking at. I think that person is not with us tonight. Um, so I just wanted to clarify that Mr. Hasbrook is here in his individual capacity. Um, and the other thing that I wanted to just clarify really quickly, just procedurally, that we have jurisdiction. There was one point where the building commissioner indicated that the enforcement request was premature. I just wanted to make it clear for the record that we're proceeding on this, that there's no impediment to hearing these appeals and we can go forward.
Nathan, please. Yeah, do you have a
Thank you.
comment?
Just one minor detail, David. For the second application, LU 2517, besides August 7th, July 31st was also another date of the newspaper notice.
I
just
missed that.
yeah.
Thank you. For the
So
record,
also,
it was
yep.
publication occurred on June 12th, June 19th, July 31, and August 7th,
Thank you.
for combining the two applications. That covered both applications. But back to Elizabeth's point, Elizabeth, do you have?
Well, it's just I just and full disclosure, I did call Nathan earlier today and he clarified for me that this should not be an issue, but because the May 19th denial to Attorney Glover in part indicates that the property is currently vacant, no use is being made that could possibly violate the NZO, your enforcement request is thus premature. I just wanted to clarify that there's nothing premature. We can proceed on the merits today in this hearing.
Maybe I'll ask Attorney Glover to address that at the outset. But before you do, counsel, can I just understand, is Mr. Hasbrook here in his personal capacity as a neighbor? Maybe could we just unmute Mr. Hasbrook, please?
Yes, 1 second,
Or
David.
in some capacity, in official capacity on behalf of the building inspector's office?
I'm gonna ask Mr. Hasbrook to unmute. Mr. Hasbrook, and
Yes, I'm here as an individual. I'm involved as a neighbor and not as a city employee. My name is Louis Hasbrook. I live at 33 Laurel Park, and 74 Coles Meadow Road is right in my neighborhood.
Okay, thank you. And just follow up. And sorry, forgive my ignorance. Are you still
Not the commissioner, but just a part-time inspector.
okay? Not building commissioner, but a part-time inspector.
Yeah.
Okay, but just for everybody's clarification. Okay, thank you, Attorney Glover, on this issue of premature filing. Can
Thank
you?
you, Mr. Chairman. Just very quickly, Alex Glover, Lizanne Glover and Pusilowski, 785 Main Street in Great Barrington, Massachusetts. Or typically that's where I am. Our computers and internet are out, so I'm not at that location at the moment. Just to when I represent the appellants here, Rilwan Miran at 82 Coles Meadow Road, and Jerry and Lynn Hinkle, who are at 78 Coles Meadow Road. In terms of your last question, I did not believe it was a premature request for enforcement because the zoning permit had been granted and was in place, and because the applicant was beginning to take some steps, however minimal, towards opening the facility. The only reason that issue came up, I believe, was because the building inspector did say in his denial that it was premature because I guess the facility hadn't opened yet. But if that were true, that you couldn't bring an appeal yet, then the original zoning permit would have expired in 6 months and would need to be renewed. And that actually wasn't my argument. My argument was there's a valid zoning permit that was granted and that was begun to be exercised. And that's why we did a request for enforcement. But if the city were to take the position that this appeal was premature, because at the time that we filed the appeal, the permit had not yet been exercised, then I would say that the permit had expired. So I don't think there's a problem with it, but if the city thinks there's a problem with it, then we would argue that the permit was not exercised in 6 months. Does that make sense?
Yeah, it does.
I think Attorney Tyne might stipulate that it was exercised since
Yeah,
he
I
said
was
that.
just going to ask if Attorney Tyne
Well,
has
we
any
have,
comment.
we have asserted that the appeal is premature.
I'm sorry, say again, sir.
Have not asserted that the appeal is premature.
I'm comfortable going ahead. Otherwise, uh, is that, how about the rest of the board? Are we comfortable with this explanation? Do we have more questions about it?
No, I think that's good. And I just wanted that to be explicit on the record.
Okay,
Thank you.
great, thank you. Okay, Attorney Glover, now I will ask you to uh, present your appeal.
Thank you very much. Thank you, Mr. Chairman. Thank you, members of the board. You know who I am now, and I represent Rilwan Miran and the Hinkles. To begin, I just want to describe to you the location of the properties at issue. These are 3 homes that are at the end of a private common drive that crosses several private properties, not just the individuals involved in this appeal. The 3 homes are all clustered really towards the very end of this long drive. It's about a quarter of a mile long. And the property owner, 74 Coles Meadow LLC, is located at the furthest end of the driveway. So all traffic to and from that property passes by both of the other houses. So as this board knows, this is an appeal of the building inspector's essentially determination in one form or another that a commercial for-profit treatment facility is legally situated in the rural residential zone of Northampton. And I don't know if the building inspector at that time took note of the fact that this is not just located in that rural residential district, but it's really off Coles Meadow Road, that it's at the end of a very long private driveway, which would make it different from every other facility I'm aware of where the driveway is shared. It's a shared common private driveway. Our position is that this use is absolutely prohibited in the rural residential zone, and no reasonable accommodation can be made because this property or these 3 properties are unique from every other similar situated property because they're all on a common drive. They're all within this private property. They're not even, for instance, separate lots in a subdivision where the city has approved a private subdivision road, and one of the homes is argued to be able to be used in this manner. It's a very different situation from that. It's this single long drive that's permitted by special permit and site plan review by the planning board. It would, with the board's permission, I would like to share the screen, I think for the only time tonight, just to show a map of these properties. I have the ability to do it. Is that, do I?
That's
Yeah, I
correct.
believe I have the ability to do it. Is that acceptable, Mr. Chairman?
Oh, sure. Well, I mean, I'm looking at it myself now, but sure, go ahead, go right ahead.
Thank you. Mhm.
While you're setting that up, Attorney Glover, um, if you're arguing that the that this effectively, because it's a shared driveway, the driveway is overburdened by the proposed use. Isn't that exactly what the land court has already ruled on?
Oh, I'll get to the land court in a minute. In
Okay.
fact, no, the land court has made no determination other than the court wasn't going to issue a preliminary injunction based on the facts as alleged at the beginning of the case.
Okay, we'll let you
And
get to that.
so, and I wouldn't ask this board, by the way, to consider, a private property right issue. I know that the board isn't really concerned about that. Uh, my purpose in raising that was to show why not only is this use not permitted, but that it would not be an appropriate reasonable accommodation in this situation for just this property. Even if the board would consider that argument for some other property in a different location in the rural residential district, there's no reasonable accommodation that will work in this particular configuration. So just very quickly, is this large enough for the board to?
Yeah, it is for me. Everyone else, can
Yep,
everyone else?
yes.
Okay, good.
Yep,
It's
thank
fine, and
you.
we have that in the packet, so we've seen.
I know you did, and I don't want to slow you down. I did just want to pull it up though, so everyone would be able to look at it, including any visitors. So I know the board understands that Coles Meadow Road runs north-south, and it's on the right-hand side here. On the left-hand side, I've labeled the three properties, and that long white line running east to west is the private common driveway. 1 minute. Not working on my usual computer, so it's a little slower. So the only other image I would like to show the board and visitors, guests, and other people is that this is an aerial photograph. Now, it's very old. I believe it's 2014, but you know how it is with Google Earth is that there are different dates on which you can see more or less depending upon the foliage and other ground cover. So this is almost exactly what you were looking at a minute ago. Coles Meadow Road is north-south on the far right-hand side, and you can see the driveway. And I think the switchbacks and possibly some of the topographical challenges, and also there's a brook here cutting across. I think they're more evident in the aerial photograph. If the board would like to take a site visit, I don't know if that's something this board likes to do, but it might be helpful as well to see.
A lot of us do that in advance of of every hearing. We'll circle back to that if people
Okay.
feel it's necessary. Could we go back to the last image, please?
For sure.
So I'm noticing that the Mirren property and the Hinkle property are also flagpole properties with their own frontage on Coles Meadow Road.
They are.
Is it because of the topography or
I,
cost?
I,
They
I
don't
don't
have
know
their own
why
road.
they were divided in that manner. I have a guess, which is because there simply was not enough frontage at the time the properties were created, at the time those divisions were made to have that many by right properties. And also the configuration would have been sort of odd. So there is a special permit that permits those flag lots and permits this particular driveway for what is apparent from the special permit, really limited use. It's recognized that this driveway is not suitable, for instance, for a road for a lot of traffic. It's just to access these three homes. So I'm going to stop the share.
So it doesn't, excuse me, it doesn't access the other homes that I see across as a couple of other lots that have frontage on Coles Meadow Road, but it's not used to access those homes.
Exactly right. Yep, it crosses over a couple, and the reason it does is because the topography, it's such a difficult area that it's impossible to do the driveway as a straight shot up through those flag lots. It had to have the curves there in order to get the proper topography to be able to actually to navigate the road.
But it only provides access to the homes of the two appellants and the subject property owner.
Exactly right. The others have direct access.
Okay.
What one property further to the north has a separate little common drive that's not part of this zoning appeal. So one property accesses off a completely different driveway.
So are you saying, excuse me, so are you saying because there definitely is a connection to Coles Meadow Road that that could not be turned into a driveway?
Um, you mean the additional lot that's not part of the appeal?
No, the other two properties that are basically filing this appeal have a direct connection based on what you showed us to Coles Meadow Road. Are you saying that could not be made into a driveway?
Yes. I mean, that his question has never come up, but this is how the lots were laid out and approved. There are not only the special permit from the planning board, but also private easements and restrictions for the shared use of the driveway. And as expressed in Northampton's bylaw, common drives in many situations are much preferred to single drives because you would have then multiple, I mean, I don't even think you'd permit it, multiple driveways right next to each other, which
Correct.
would be very unsafe. So I don't know whether that was, I don't see how that would be possible. Uh, so the driveway itself accesses what were intended, I think, by the city, but also by the original developer to be three sort of a low impact personal family homes. There is a private restriction not relevant to this board's determination that it be limited for residential use, as is typical for like every common drive or shared driveway agreement I've ever seen, because people don't share their property in order to have a business or some higher impact use go in on their shared property. It is used for the obviously driving to and from the homes. It's used, the families use it for walks. And it's also used by the school age children of both Hinkles and Mirans to walk up and down that long driveway to meet the school bus, which does not come up to the homes. It's at the bottom of the driveway. As I said, it's about a quarter of a mile long. It's narrow. It has varied topography. There are certainly places where uh, you can't even step off of it to the side because of rock outcroppings, a drop off. Some places it's flatter. It has a road, excuse me, a brook that goes under it with an actual sort of bridge culvert. So there is some wetlands area as well there. It's a really tricky location, which again is why the driveway is constructed or designed that way. There are several places where two cars can't pass. There were required and have been constructed turnouts, right? The city required that. And there are some turnouts to permit areas where vehicles can pass, but there are many areas where they can't. No way could two trucks pass each other on this driveway. It's steep. Winter driving is sometimes an interesting challenge. Uh, and and again, it's really only ever meant to access homes. I'm sure the board is aware the described use is a for-profit 16-bed transient use treatment facility. I say transient because although that's not in the title of the treatment facility or its description, this is not designed as a group home or even, to use the term in a non-defined way, halfway house, a transitional facility for people to live as their home while they're doing something in their lives, or to have assisted living, such as there's one in this area where there's six mentally challenged or disabled men live together in a group home. It's their home. They live there. They do have staff that comes in and out. You'd never know it if you looked at it. It's just a house. And that to me is what constitutes a residential use. And under the Northampton zoning bylaw definition, a single housekeeping unit. What is being proposed here is not a single housekeeping unit. It is 16 individual clients who come and go at different times. The stays really are expected to be anywhere from days to weeks. They might be longer, but this is not a residence in the sense that it is not a people coming together to choose to live together. They presumably, the clients have homes. They are staying temporarily for treatment. The primary purpose of this facility is not housing. It's not housing with an added benefit of staff support and therapy and other amenities. It's not that. It is treatment where the clients spend the night. Those are two very different things, and it really distinguishes a group living home, which under Northampton's definition may constitute a single housekeeping unit and thus a single or two family residential use that's permitted in the rural residential district.
I have a question, if I can interrupt on that point. You said that it isn't primarily going to be used for living. What is there something that suggests that if there's another use besides living, that it takes it out of the possibility of a residential house? Is that I'm saying this backwards, but my question goes to that assertion that because it isn't a primary living use, that it therefore can't be a residential property. And so I'm trying to figure out and dig into that a little bit.
So I think to answer the question as broadly as you posed it, I think the answer is that's not what I'm saying. But let me see if I can say it better and see if it makes more sense. I think the threshold question here is this or is this not a residential use? As you know, Northampton defines residential use as essentially any number of persons, blood related, not related, in any sort of legal sense, living as a single housekeeping unit. I think that presumes that the purpose of the people being together is to live together, that this would be a residence, a home. These people, and again, I would contrast the
Do you have
type
any
of
basis for saying that that presumes what you just said, that that presumes that the primary reason is for these people to be living together? Because I think the presumption, I just want to get more on that presumption because,
What's it based on?
yeah,
which presumption?
what you just said is that there's a presumption if it's residential, that they're living together for the reason of because they're living together, and that's the primary reason. I know it's a little circular, but you suggest that it can't be residential unless the main reason, there's a presumption it can't be residential unless the main reason is for living together.
Okay,
I think that's what I heard you say.
If I use the term presumption, then let me take that back and phrase it a little bit differently. In a kind of a group home facility, and I'm going to use that small g, small h. So I'm not looking at any particular definition. I'm looking at the understanding that you have a number of people living together in some type of a supportive environment, whatever type of supports you may need. They may have one kitchen, and they may be there not for their entire lifetimes, for shorter periods or longer periods, but the purpose of them being there is to provide a home. I mean, it's their home. That's where they're living. In this type of facility, it's a treatment facility where people sleep. The fact that there's a kitchen, a single kitchen, doesn't mean in and of itself that that's residential. The fact that people sleep overnight doesn't mean of itself as residential. Again, it's really a transient type of occupancy. It's not where people are residing. They're never going to vote. They're never going to transfer their address there. They're never going to have a medium stay. You know, I could stand corrected, but there's not an expectation that they're going to be there for 3, 4, 6 months. This is a treatment facility, like an inpatient treatment facility where people stay over. So it's very different from the type of group home where people are living there and all supportive services brought to them. It's a different, it's more like a, like an outpatient, it's more like an inpatient sort of treatment facility. It's not there so people can have a home. It's there so people in transition can have treatment, and they have it staying over.
I think it'll be interesting to hear later from Attorney Tyne on these points, because I sort of inferred from the materials in the city's file that, again, this is also not a phrase used in the zoning ordinance, but that it's more like a therapeutic residential community, giving sort of a stable home life to the occupants. But I'm speculating myself. We'll hear later, I'm sure, from
Yep.
Attorney Tyne on these points from the perspective of the property owner, and I think that'll be very relevant to this discussion. But why don't, if there are no other questions right
I've
now,
got,
let Attorney Glover continue.
thank you, I'm sorry. Uh, yeah, to address that, I think that's a description that gets, maybe put out there to parents as to why they should choose this facility, but because they say it's home-like and residential doesn't mean it's a residential use, meaning it's these people's home. It's their residence. I mean, it's this sense of at least some type of predictable permanency, intention to be there. It's not. It's some, again, you'll hear, but the stays can be very short. This is days to weeks and maybe months, but it's not a house. It's a treatment facility where people stay. But just to run down the list, so it's a 16-bed facility. So there will be intakes and discharges for 16 people on irregular schedules. It's staffed 24/7 with 4 to 5 staff members. So there will be staff members coming and going with shift changes, parents and other visits, food and supply deliveries, maintenance service, social workers, mental health treatment providers. This is a very sort of much more heavily impactful use than a home, even a home that has a lot of bedrooms. It's much more impactful than a big home. I am assuming for the purpose of this permit and for court that the clients will constitute as disabled persons. We haven't really gotten that far into it, but I'm not arguing they're not. I have no information, so I'm assuming that they would qualify as disabled persons.
Well, could you address the issue, which I think is the ultimate crux of the matter, and that is the fact the discrimination issue, the fact that as I read the materials, what this is really about is the protection afforded to certain persons against discrimination. Can you comment on that?
Absolutely. And I agree that that's one of the biggest issues. I do think the other biggest issue is this a single family or two family? Is a single family residential use? Or is it something else? But yes, so in terms of the question of discrimination and disability, 40A and Mass General Law 40A Section 3 says that municipalities and zoning cannot treat uses for disabled persons any differently or worse than they would the same use for non-disabled persons. The law is very clear about that. It's in the list of protected zoning uses. And then I'm just opening up that page so I have the language in front of me. And then there is also a requirement of consideration for whether there's some accommodation that can be made for the particular use, if that's possible. In this situation, I'm not aware that Northampton has permitted a 16-bed congregant, sort of a transient living facility like this in the rural residential district. So I'm not aware that there's a similarly situated facility that if Northampton were to say, no, this doesn't constitute a family, single family residence, that you would be inconsistent or treating this facility different because it was disabled. The appellant's concern about this facility is not that people are going to be disabled. I will say that when they first heard about it and knew nothing about what it was going to be, they were panicked for all different kinds of reasons, as I think a lot of people would be. Understanding a little bit more, but not entirely, what the intended treatment or the intended population will be. The concern is safety. The concern is excuse me, one second. Sorry, we're sharing space because of my office issue. The concern is safety, and it has nothing to do with people being disabled or not being disabled. It's a 16-bed facility with this level of service. There is a court case that came out in March of 2025. I actually did not cite it in my brief. It's so new. It's the Supreme Judicial Court. I sent a copy to Attorney Seawald today, just because I didn't have it in the brief. It's 495 Mass 587. It's a realty company against the city of Fitchburg. And Fitchburg said you can't have a treatment facility for disabled persons because it doesn't meet the definition of family under Fitchburg's zoning bylaw. And the Supreme Judicial Court said, first of all, that agreed that it didn't fit the definition of family, and then said there's nothing about 40A Section 3 or disability laws that mean a municipality can't enforce its zoning bylaw. Almost exactly the same case, and said if it's not a family, thus not a single or two-family residential use, the city can just say no. So in terms of the disability aspect, Northampton can enforce its zoning bylaw. And if it is Northampton's decision in supporting its zoning bylaw and how it applies to all residents of Northampton, not just this particular situation, the board has to ask itself, is this or is this not a single or two-family residential use? Is this a residence, or is it something else? Just in terms of the interest of fairness and equity, the applicant was informed before they even applied for a license that this issue had been raised. I think when the land court, there's a land court action as a private property rights issue having to do with the use of the driveway. I think that was filed. There's still, at that time, the license had not been applied for. So this facility came in with full knowledge that there was going to be a question about whether or not it fit within the zoning. And if so, whether it, even if it did not, whether there would be some accommodation that could be made. But in this situation, the Supreme Judicial Court said, if this board finds this is not a residential use, then you're entitled to say no, that the use is not permitted and the facility cannot operate there. If this board were concerned about, this use compared to other uses that may have been granted, of which I'm unaware, this is really different because this is the end of a very private, narrow, long driveway. This is not a facility that opens onto a public or private street. All of the traffic is going up and down this driveway past these two homes on private property with no traffic lights, no bad sight lines in some places, the winding road. I mean, it's not safe even for the users of the facility. In my view, I'm sure they've made a determination it is. So I'm just going down. We did talk about the expiration issue.
Can I just, clarify in that case that I just did a really quick check on that.
Good.
It's really quick. So
yeah,
you know how this is.
Yes,
but
I do.
It just looks like, from a very, very quick purview, that it looks like it turns on what the local ordinances are.
Oh, 100%. That's what I'm saying. Exactly. So in that case, the local ordinance appeared not to permit that treatment facility. And there was a fight about that, and it went up. And the finding was, yes, the local ordinance prohibits it. And yes, Fitchburg can enforce its ordinance or can say, this isn't a single family residential use, and we can say, no, you can't do it there. In our case, the language of Northampton zoning bylaw defining single-family residential use or residential use is different from the Fitchburg case. So I'm not suggesting every bylaw has different, almost every bylaw has different language. So what I'm saying is that if this board can be confident that if it determines that this 16-bed, facility is not the same as a home or residential use, then you're entitled to make the determination to overturn the ZEO and say, no, we're going to enforce our bylaw. And no criticism of him. I mean, he did a diligent job and did research and came to his conclusion, but ultimately it rests with this board. So there's no trumping the definition of family. If this board feels that this is not a residential use, then this board can say freely and without concern about laws of disability, no, you can't put it at the end of this driveway. I think I would just, I'm sure we'll have more to say, but I'll just wrap up to say, in summary, this use is not permitted. It is gravely harmful to the other two homes that have to share this driveway. It is fundamentally changing the character of their private property on their driveway, a quarter of a mile into the woods. It is fundamentally changing the safety, their own use of their driveway and their, walking and their children's use of the driveway. It is going to destroy what they thought they had for homes. Because again, this is not just, oh, I'm going to have this big facility next to me on the road. This is off this private way at the very end of the private way with all of that traffic coming and going up and down. It's just wrong. It's just the wrong location in any event. This city regulated this use by requiring and issuing special permits and site plan review for these flag lots. You can't just put those flag lots in the common drive in. It's regulated because there are safety issues, access issues, public safety issues in terms of fire, ambulance, and police access. So to permit this large facility really is going to undo all of those protections and the guidelines that Northampton has for flag lots and for common driveways. It's unquestionably going to increase the activity and amplify the sort of the burden on those properties. I mean, I don't think there can be any argument it will change things and not for the better. I'm not aware that Northampton has ever granted a permit or permitted a facility like this and called it a home, a single family residential use or two family residential use. And if you were going to consider it, this is not the location for it. And I doubt you would ever have had the exact same physical layout situation. So you might say, I don't think you have, either it's single family residential or it's not. But if you were looking at accommodation, you might consider, well, is this on a road? But it's not. It's way at the end of this private driveway. So
assuming that there's no discriminatory intent here, which I am very much willing to assume, if hypothetically there were only 5 people who would be enrolled in a similar program in the same house, the same location, would your analysis change?
That's a really good question, and no, my analysis would not change, and here's why. The number of people that's going to be there makes it worse, right? It's a huge burden and change in the use of the property. However, it's the nature of the facility that makes it not permitted in the rural residential district. That's the question. Is it permitted? If there's one person there, I mean, if it's a 1-bed facility for someone coming and going for this type of treatment, not living there as their home, not, but coming and going for this type of treatment, that would violate the zoning bylaw.
So if it were a homeless shelter for people with mental health problems, then you'd have no
So
problem with that because it's more of a permanence? Is the issue the temporariness?
I think the issue is two things for this facility. It's the transient nature of the stay, and it is the fact that people are not coming there to be housed. They are coming there for this supportive, home-like, home environment treatment. And as opposed to they're coming there for housing. Now, I think the argument on the other side is going to be, well, they're stepping down or they need to be housed here because for whatever reason, they're unable to be at their home at this time. But that really doesn't answer the question as to whether or not this is this is a residence, whether this is a single housekeeping unit. I mean, again, a kitchen, the existence of a kitchen doesn't make something a housekeeping unit. The existence of a bed plus a kitchen does it in and of itself and make it a housekeeping unit. This board is going to decide for Northampton whether this use constitutes a housekeeping unit in the rural residential district where it is otherwise flat out prohibited because Northampton created the rural residential district to have this agricultural and quiet residential use. So I think, Mr. Chairman, the flip side of your question, which is something that I think is also, a little bit hard to answer, is that since Northampton doesn't limit the number of persons in a family.
I was going to ask Attorney Tyne, based on the same analysis, could there be 50 people there?
Right. Could there be 50 people? I have to say, I think the answer is yes, if the infrastructure supports it, if the state sanitary code supports it, if the building code supports it, if you've got the right lot coverage, you have all your permits. And let's just say there's 50 people living there as roommates. They're all going to live, they don't pay rent, they just all share it. And I mean, they may pay rent, but they all together are calling it their home. Then, I think based on at least the analysis at the level we're doing, that's going to fall within Northampton's zoning bylaw as a single housekeeping unit. Could have a couple roommates, could have many roommates. I don't want to suggest, very impactful uses, but, you could have a single family house shared by a number of adults who are sharing the rent or sharing the, living there. They're all owners. So you got 50 owners, they all live together. I mean, I don't know how you would provide all of the sanitary needs and space needs and building code, but I think those would be the limitations.
Right. And that is certainly, I think in Attorney Tyne's materials, he acknowledges that the number would always have to be subject to reasonable safety and sanitary and building code constraints. I have, first of all, I want to turn, it's getting so dark here. Excuse me, I just need to turn a light on. I have quite a few questions for Attorney Glover, but I want to make sure to ask if any other board members have any other questions at this time.
Just
Yeah.
procedural. Is that just to, remind ourselves that what we're tasked to do is not decide whether this is, appropriate use of, whether it satisfies code and appropriate use of the property, but whether the building commissioner erred in issuing a building permit in the first place. And I'd like to stay on that path as we're moving forward. It feels like it's we're talking more about should they be permitted to do this rather than if the building commissioner erred in issuing the permit, which are two separate things in my opinion.
Separate things, but I think, well, I'm sorry.
They're related.
Somebody else have a response to that?
I was just going to say that all of the information, most of the information we've been discussing I believe goes to the only question under zoning, which is what the building inspector's determination is based on, which is this or is this not single family residential? And so all of the discussions we're having about use go to two things. Does it fit within Northampton's zoning bylaw permitted use in the rural residential district? And for the purpose of the appeal, I need to show that there's harm or anticipated harm from the use. But yes, that is why these are all relevant. Is it a single housekeeping unit or not?
Right. And that goes to the issue of our ordinance for in fact does not have a limit on the number of unrelated occupants who can occupy a single family residence, right? So
Yes.
David, I was
Right.
going to ask, and maybe this is towards Nathan. I would like to, again, I mean, I went over all this material, took me hours today. I would like to see the actual verbiage of the bylaws at this moment of what the rural residential single family home allows.
So I have the definition, so it allows single and two family residential and two single family residential homes. So the definition of family, which is what you need in order
Yes.
to interpret that, is section 350 colon 2-7. And I have a quote, an individual or two or more persons who may or may not be related by blood, marriage, or legal adoption living together as a single housekeeping unit. So any number of persons
and
living
then the
together.
issue to Maureen's point, the problem with just saying we want to stick to whether the building inspector erred, at least one of the bases for the building inspector's approval of this, I believe it was a zoning permit application, right, to issue a building permit, because there's no building permit yet, if I'm not mistaken, was that one, there's no limit on the number of individuals who can constitute a quote unquote family dwelling in one unit. And two, it is unlawful to discriminate against people with disabilities. And I believe that's in a sentence why we're here.
So
And I agree, David. And three, there's no condition in that single family, two family definition for how long, the expectation of how long somebody will reside there. Although I'm extremely sensitive to your distinction, Attorney Glover. There is no wording in that identifies that it's their permanent residence. So
That's a good.
I
I think that's equally important to the fact that
think we
there's
have
no limit on the number.
right. The
So
question
to-
is, yeah, I'm sorry, go ahead.
to feel really confident in my own mind about this, I would like to point to Chapter 350, Section 9.2, which is nonconforming uses, structures, and lots, which identifies ways that this ordinance shall apply to any change or substantial extension of such use to a building or special permit issued after the first notice of said public hearing, and to any alteration of a structure, which we know that the building commissioner is completely in compliance of, and then, or for the same purpose in a substantially different manner or to a substantially greater extent of use. So I want to feel confident that our building commissioner took this into account and is in total compliance. And I feel that Commissioner Ross did his homework, but I personally want to hear some explanation on how his decision was in compliance of this.
Could I just address that? I believe that section isn't relevant to this
Could
to
be.
this
You could
factual
be right.
situation. That applies to pre-existing non-conforming uses and structures.
Right. And this
So it
is
applies to essentially what we used to call grandfathered
right.
uses.
Yeah, I agree.
Actually, no. Okay, so that's all within non-conforming? Okay.
It applies to pre-existing non-conforming uses or structures where there's a proposal for an alteration or expansion that would require, and a zoning permit application would be denied with an
Okay.
instruction to apply to this same board for a finding that the proposed expansion or alteration, whether it's the use of the structure, would not be substantially more detrimental to the characteristics of the neighborhood as the original use. I think,
I think we're okay. I found the wording vague because it doesn't say non-conforming. It says non-conforming uses in the title. And the last line of the ordinance identifies that
Right.
notwithstanding the above, nothing in this section shall be construed to allow a change of a non-conforming use to a new non-conforming.
Right.
That was
It
relevant.
touches
Okay.
on a theme that we're sort of tiptoeing around insofar as we're talking, certainly from the perspective of the appellants, about what they view as a substantial expansion. But the underlying basis is it's the expansion of a use of a single family residence that currently is not non-conforming in any way. And um, and so it really goes more to this issue of whether um, this expansion is sort of excessive or creates hazards or otherwise. And we know from the building inspector's letter of denial uh, of the request by the appellants for the enforcement that the building inspector was concerned about uh, avoiding any discrimination against a protected class, in this case, people with disabilities, in otherwise uh, limiting what I'll call informally the expansion of the use. Does that make sense
Could I,
to people? Yes, yes,
could I,
Attorney.
could I address that? Thank you. Thank you. Just really quickly, first of all, is that the reason that the reason that the temporal nature of the stay is relevant is to the interpretation of that phrase in your zoning bylaw, living as a single housekeeping unit. So if you're there for a day, are you living as a single housekeeping unit? That's why I was raising the issue of the timing. But to go to the disability issue, 48 section 3, it's not, so just saying no to a use that involves a disability is not discrimination. The statute 48 section 3 says imposition in part that the city or town shall not discriminate against a disabled person with local land use laws. Imposition of health and safety laws or land use requirements on congregate living arrangements among non-related persons with disabilities that are not imposed on families or groups of similar size or other unrelated persons shall constitute discrimination. In other words, it is not discrimination to enforce, as the Supreme Judicial Court said, a definition of family, even if that means you're saying a facility for treatment of disabilities can't go in there. If it's not within your zoning definition, you can say no. And that's what 48 section 3 says. If you've said yes to this type of facility in the rural residential district otherwise, then you would be discriminating, arguably, to say no to this one.
Does that go to the issue, though, that would take some time to research, and that is whether the city has, I think you've alluded to it earlier,
I'm not aware of it, but that doesn't mean it's never happened. I don't know.
but does it go to that question? Does that become a
It's,
question for the board?
it's something the
Are there
board,
other examples where these sorts of, I'm also looking at this at 48 section 3.
It's like 5 paragraphs down or
Yeah, no, I've got the language that are not imposed on families or groups of similar size or other unrelated persons. Well, anyway, let's table that, and it
okay.
could become something for us to try to look into. Again, we are not a court of law. We are not, we are volunteer citizens here, but we're doing the best we can. So, what about what can you address Attorney Glover from your perspective? Attorney Tyne may have a different one. What what the land court decision said and did, and how it affects this analysis?
Sure. It doesn't affect this analysis even a little bit. That had to do with the a statute regulating private land use restrictions that essentially prohibits disability discrimination in such restrictions. It also had to do with an argument that, well, I think that's really what the judge was talking about in that decision. To back up, there is a restriction, as there almost always is on this shared driveway. My clients, we filed suit in the land court asking the court to say this would overburden the driveway use and it would violate the restriction. And we asked for a preliminary injunction, sort of right at the beginning of the case. Judge, tell them they can't start this use while we're figuring this out. And the judge was very thoughtful. She had, I think, 2 separate hearings and ended up saying, I don't think I can do that as a preliminary injunction. She
So
did not
so there's no decision on the merits in that.
not at all.
Okay.
And I don't think she made the findings. I don't think she made the findings the way they were characterized in Attorney Tyne's brief. But no, it's still an open case. We're in the middle of discovery. There's no decision. We'll have a trial or a dispositive motion. But
If and when there is a decision, or let's assume, just for the sake of argument, that the decision was already rendered by the land court, in your view, would that provide guidance to this board in this proceeding?
no, sir, it wouldn't. And the reason is that has to do with private land restrictions. You are determining what is permitted by the city of Northampton under your zoning bylaw.
We don't get into private rights
Correct.
among private parties under private restrictions.
There's nothing about the zoning. I think sometimes it gets conflated, and I think the conversation, it's really important to keep them clear. So, for instance, the private property rights, let's say we lose that case and the judge says, no, you can have this facility even though you just are agreed to share property with people for a common drive. Northampton, so Northampton the judge could say, there's no problem with the facility based on private property rights. Northampton could say, it doesn't fit within our bylaw. We don't care what you can or can't do private property right wise. This does not fit in our bylaw. And the opposite is true.
Northampton could finding that the proposed use would not excessively burden the shared driveway easement, isn't that relevant to some of your arguments that that this is just putting too much of a burden on that driveway?
So the reason I made those arguments is simply to establish there's standing here, that concept that my clients have a dog in the fight, that this matters, that they will,
I understand. Okay.
that there will be this increased traffic.
Okay.
So I think they're really two very determinations.
Okay.
There are going to be certainly facts are going to overlap
Right.
quite a bit.
So, and then I do intend to move on here. This is taking a lot of everybody's time, but we're also trying to be as thoughtful as we can about this. I assume Attorney Tyne's going to want to comment on this, and we'll turn this over to him very shortly. But Attorney Glover, from the perspective of your clients, is there any relevance to the licensure that the property owner is going to be operating under with the state? relating to any of these issues, discrimination, whether it's a single family dwelling unit, et cetera?
I don't think, to the extent I know right now, I would say no. I think that whether or not it requires a license of the type that they say they're going to get or they've gotten doesn't answer the question of whether it is people living in a single housekeeping unit. Uh, Now, the type of license could be relevant if it would define this use clearly as a use permitted in a different, like it's a hospital or it's a whatever boarding house, bed and breakfast. There's some provisions in your bylaw for different uses that have different types of licensing. But for your purpose tonight, I don't think so. I don't think it makes a difference.
Are there any other questions
Yeah.
for, and obviously we will always circle back, but yes, Elizabeth?
Yeah, I had a question that goes to the discriminatory intent piece. When I read Attorney Tynes' letter and the attached emails that suggested that your clients were opposed to these people that are moving in or hope to move in, as opposed to a whole gaggle of Smith students that would move in. That in my experience as a student, I was moving around every few months, so that they could be doing that as well. It could be a revolving door of people. So if you could address what sort of appears on its face to be a discrimination against this population, which I also saw just one reference to eating disorders as opposed to anything else of the mental health variety issues that might be raised. Why don't you address those emails that we saw?
Sure. I think it's grossly unfair to bring up the communicate, not by you, excuse me, but to have it injected into this conversation that my clients heard that there was let me just back up. They were told by the seller of this property that this was going to be a nice family moving in and they would love them. They had no idea that this facility was going in on sort of this back on their driveway. They heard it in bits and pieces. And if you look at the original application for the zoning permit, it says nothing. In fact, it actually also says there are no special permits on this property, which was untrue. It made a couple of, there's no water on this property. There is water on the property. Actually, I think it said they didn't know. But you had no idea what was going to be the use from that initial application. There was like a 2-sentence description. And I know they were very initially concerned. Is this a prison population? Like, what the heck? They didn't know. I'm not sure there is a commitment to eating disorder, but that was not something that they were told initially. And they, since they've had the nature of the facility defined, which is, as I understand it now, is, adolescents in need of either step down or some other kind of treatment so that perhaps they can transition home, whatever. I'm not sure it's tied to eating disorder, but who have some type of mental or emotional disturbance that requires this kinds of treatment. So they weren't aware of that, and they have not repeated those concerns since. They're absolutely overwhelmed with concern about the prospect of this facility going in back there. And we've not raised the issue of the population ever since I got involved, ever. That is not an issue. The other thing I would say, which I hate to even follow up because it's going to sound like I'm hedging, but I'm not, is that their intent doesn't matter at all. What matters is Northampton's intent. The discriminatory intent is whether Northampton has one, and I know, knowing Northampton as long as I have, that you do not. Probably no one in Northampton is gonna have a discriminatory attitude towards disabled persons. But yeah, no, my clients would vociferously disavow any sort of concern against people with disabilities at this point.
In other words, the intent of your clients is not the issue here.
It's not the issue. And I think that their initial reaction, at least I will say, I as a human being am sympathetic to having an initial panic reaction when you get this information as, not what was represented to you initially and not having a full understanding of what was actually happening.
Right.
So I do think that 16 Smith students would be daunting as well. I knew we were going to use Smith students as an example sooner or later in this hearing, but yeah, no, and that it really is because they're disabled people, you have more traffic. Okay, but that doesn't mean you're discriminating against disabled people. And the reason I say that is because you have full-time staffing, right? You have treatment social workers, people coming and going. I also would suggest really the visitation that you're going to have is probably going to be more intense than you'd have for a Smith student living there. You're going to have presumably families and friends who would come visit. So you've got that traffic in and out that you wouldn't have for just a person living in their home. So
I'm not sure I would agree with that, but let's move on.
if I could have visited my kid in college every single day, I would have, but
Students will have a lot of traffic, but anyway.
Any other questions for Attorney Glover before I think it probably makes sense to give Attorney Tyne the floor? Any other questions? Okay, obviously we can always circle back and probably will, but Attorney Tyne, do you have some thoughts to share?
Sure. Andrew Tyne for 74 Coles Meadow LLC. My office is in Barrington, Rhode Island, not Great Barrington, Barrington, Rhode Island, 18 Maple Avenue. And yeah, I've got a number of comments. Obviously, we've kind of, I think, been all over the place, so I got to try to address these in some particular order. I guess first, with respect to the reference to the use of the home as transient, I think that's a mischaracterization. Dennis Thoreau, a licensing expert that's assisting my client in obtaining the licensing, his affidavit has been submitted to this board, and it describes the nature of the program and the lengths of stay. He says in his affidavit that the stays are days to months. And the reason it's days to months is because the kids, the adolescents that are participating in this program are not compelled to be there. This isn't prison. This isn't something they're forced to do. This is something they're doing with the consent of their parents, but obviously can withdraw from the program. They can withdraw from the house. They can leave under certain circumstances. So someone may enter this program, live at this house for days. They may not find it to be a fit for what they're trying to accomplish, and they can leave, obviously with the consent of their parents, etc. Or they may be there for months. That doesn't make it transient because something doesn't work out. I may rent an apartment and stay for days and it may not work out. That doesn't mean I'm transient. It means I lived there for days and it was my home for days. Federal law speaks to this, and the FHA is relevant with respect to this case because the FHA allows my clients to request a reasonable accommodation with respect to the use and occupancy of this property for this purpose. The FHA says, case law has said that average stays of 15 days in a facility or program or a home for the disabled, an average stay of 15 days has been considered non-transient because it needs to be non-transient to obtain protection under the Fair Housing Act. So federal court has said you could have people that are staying for days and people are staying for months. And if it averages more than a couple of weeks, the court has said, we view this as their home during that period of time. It may not be an ideal situation where you and I want to live somewhere for years, but not everyone has the benefit of that situation. For these kids, for these adolescents, for the period of time that they're staying at this home, it is their home. And the license for this program makes it very clear to the people running this program that they're providing a home for these children. And if you look at some of the citations that are in my papers, or if you want to read the licensing law in its entirety, it's 606 CMR 3.0. And the licensing law, I can read a couple sections to you. I mean, the intent of this license by the Department of Early Education and Care, it's adopted, this code is adopted under MGL 150, 15D, I'm sorry. And it states that the policy of state government is to assure that every child has a fair and full opportunity to reach his or her full potential. In order to fulfill its mandate as the agency responsible for licensing residential programs, the Department of Early Education and Care has developed specific standards for residential programs to provide this opportunity to the residents they serve. And then if we get into the detail of the licensing, which is in the CMR, it talks about the home that's to be provided by the people who are obtaining this license. And it gets down into the details of the physical requirements of the home, because this is to be an environment that allows kids to develop and progress and gain stability so that maybe they can go live back at their parents' home or somewhere else, whatever the next step is for them. But the point is that this is an environment that is conducive to them as kids so that they can develop appropriately. And that goes to the big picture here, which is, what are the appellants saying here? What are Attorney Glover's clients saying here? That this needs to be somewhere else, not in a residential neighborhood, is what they're saying. The whole point of this licensure and the program parameters is that it is in a residential neighborhood. You can't put these children in a strip mall or an industrial park or somewhere that's not accommodating for kids to develop and grow. They don't need to look outside at a dumpster or a train or a tractor trailer truck or whatever's going on. This is in fact a perfect environment for this. The lot's giant. It's over 4 acres. There's great distance between this property and the others around it. This really isn't relevant to this board's analysis. I mean, the board has to look at something very specific, which I will get to, but this is actually a very appropriate setting for this because it's secluded. It's quiet. This use isn't going to generate more traffic than other uses, which Attorney Glover suggests could be established at this home. Her clients in this email chain talked about buying the home and renting it to Smith students, I'm sorry. And this is an 8-bedroom home. My client is proposing 2 beds per bedroom, and the house is giant. I think it's 8,000 square feet. I think it's classified as a 2-family. Maybe it's because it's got an in-law apartment. It's a giant home on a big piece of property with only 8 bedrooms, which isn't a lot for that size of a home and that size of a lot. Arguably, my clients could rent it to 16 Smith college students, as the abutters wanted to do to prevent my client's use. Would that create more or less traffic? Again, not something, I don't think that's something that this board's deciding, the amount of traffic, but arguably 16 Smith college students, 16 cars coming and going to school, coming and going to jobs, people visiting them, as opposed to 16 kids without cars and 4 or 5 staff on shifts coming and going. It sounds to me like there's less of an impact from a traffic perspective with this use versus other uses, which I think the appellants are suggesting through the documents that they exchanged amongst themselves is appropriate. But what is this board deciding? I think this board is deciding something very specific. Does this property allow for a family to live there? Yes, of course. This single families, 2-family neighborhood, families can live there. Do the families have to be related? Under the definition of family per the ordinance, no, the family does not have to be related. Could the family be a group of college students? Apparently, the appellants suggest that a group of college students could live there as a family. So could a group of unrelated people who are not college students live there as a family? I would assume yes. So what is the real question? The definition of family within the zoning is that it has to be a single housekeeping unit. Now, there's no further definition of that. So that's now within the purview of the board of what is a single housekeeping unit. A single housekeeping unit, I think in general, is living in a house together, maybe cooking together, maybe sharing some meals together, maybe watching TV together, living in an environment together. You can't say that they're responsible for doing domestic duties. Does that make you a single housekeeping unit if you perform domestic responsibilities? I don't think so. My kids leave the dishes on the counter and don't take out the garbage, but I consider them part of my family. I cook for them too. They don't even cook. So, is it living together, socializing together, doing some things together? That's what these kids will do in this home. They'll have their beds within their bedrooms, like any other family. They have a group room to watch TV. They have one kitchen. They will have assistance from someone preparing meals for them because it's necessary because they are children. But in general, they're living as a single housekeeping unit. Now, I think the appellants are saying you should disqualify that or not find it a single housekeeping unit because they're in a program, because they also are disabled, because they have mental or behavioral health issues. So I think the appellants are saying this board should disqualify these children living together as a single housekeeping unit. You should not find that because they have behavioral health issues and mental health issues that require treatment of some sort, require that they be in a program. And I think if this board finds that that's the reason why they're not a single housekeeping unit, because they have healthcare issues, that's discrimination. That's saying you can't be a single housekeeping unit because you have mental health issues. I think it's irrelevant that they have an overlay of a program for where they're living. I don't think the board should really be considering that. As to the real facts we have as to them living as a single housekeeping unit, all we have is the affidavit of my client, the affidavit of his professional who's obtaining the licensure, the description of the program within the CMR, and all those facts. If you read those affidavits, if you read the CMR, the code for the license, you'll see that this is a program to provide housing, residential housing, for these adolescent students, these adolescents that are struggling because of their mental and behavioral health issues. And I think that we've got that first question, which is this qualify as a single housekeeping unit? And I think the building commissioner looked at this closely and said, well, the definition is broad. So yes, under our zoning, it's a single housekeeping unit. And secondarily, I think the building commissioner said you can't disqualify it from being a single housekeeping unit simply because the individuals are disabled, having these mental health issues which require them to be in a program because they need a structured environment to live within. Which brings me to the third issue, which is if this board has questions in their mind as to whether or not this is a single housekeeping unit and feels as though for some reason it should be disqualified from being considered a single housekeeping unit, my client has requested a reasonable accommodation. And a reasonable accommodation under federal law is appropriate. This board can consider that. This board can make any modifications or changes, in fact, is required to make modifications and changes to their local laws, the ordinance that are applicable, how the definition of family will be applied here, anything to allow access to housing for disabled individuals in furtherance of the Fair Housing Act and the Americans with Disabilities Act, and also GL 151B, which all require municipalities to provide reasonable accommodations for disabled individuals to allow them access to housing. It's reasonable. My clients, the reasonable accommodation test it's actually kind of simple. Is it reasonable and necessary? It's reasonable. 16 unrelated people could live at this property. So why is it unreasonable to allow 16 unrelated people who are disabled to live at the property? Is it necessary? Well, this program, there's a need for these types of programs. The Department of Early Development is licensing this program because there's a need, because they have children that need to be placed in homes and they need places to put them. And so there's a need. And without this board allowing these types of programs, housing for children, to exist within residential neighborhoods within the town, then this board would be denying access to those homes and creating, obviously a problem for this licensing authority in accomplishing its mission. In no particular order, I just want to address various things. This question, I think the chair asked, was going to ask me, could 50 people live at this property? Could a family of 50 people live at this property? A traditional family, everyone's related. 50 related people live at this property? No. Has the city of Northampton ever told a family, your family's too big, you can't live at this property? I doubt it. I doubt that's ever occurred. But it could occur, because under the building code, there's a section called the sanitary code, which has square footage requirements for housing. The square footage requirements for bedrooms. There's also square footage requirements for livable space within the home. So a bedroom, and I think the first, don't quote me on this, but there are numbers such as this: for the first person within a bedroom, there has to be, 80 square feet. And for the second person, there has to be 50 square feet, something like that. So bedrooms have to be an appropriate size. So for this house, because it has 8 bedrooms, how many people can you fit in each one of those bedrooms? There's a limit. It may be more than 16. My client's only putting in 16, but maybe some of those rooms are a little bigger. Maybe if Smith College students came in there, maybe they could put 3 people in a couple of those rooms if they're big enough. But there is a limit. There's a limit under the code as to how many people can live at a property under the sanitary code. The Fitchburg case, I want to talk about that quickly. That was my case. It was a sober home. It was a triple decker, and my client was providing sober housing for individuals in recovery from substance use. And the city of Fitchburg's definition of family essentially is that you have to be related. It's entirely different than Northampton's definition of a family. And if you go throughout the Commonwealth, there's great variations in the definitions of family within the local zoning. The most restrictive I see are the ones that talk about every family member needs to be related. And, Fitchburg has such a definition, something like that. And the lower court agreed with me that they couldn't enforce that definition. And the Supreme Court agreed with the city of Fitchburg that they could enforce that definition, that the city of Fitchburg could enforce their definition of a family and only allow related people to live together as a family. And that would not violate 40A Section 3. However, that doesn't apply in this case because Northampton's definition of a family is different. And Northampton has to consider whether or not it's a single housekeeping unit. It has nothing to do with the relationship or relation of the family members. Further, the Fitchburg case never got to the point of considering whether or not a reasonable accommodation could be provided. We settled the case and it was dismissed, and there was never a reason to consider or not whether or not a reasonable accommodation should have been provided. But irrespective of the Supreme Court's decision under state law, Fitchburg still had an obligation to consider whether or not a reasonable accommodation should have been provided to allow these unrelated disabled people to live together. Just as I think this board has a 3-part analysis. Is this a single housekeeping unit? If so, stop there. The use is allowed. If not, is it discriminatory to say it's not a single housekeeping unit because the people are in a program, because they have mental health or behavioral health issues? Well, if you're disqualifying it for that reason, that's a violation of 40A Section 3, paragraph 4. And then the third issue is, well, if you don't think it's a single housekeeping unit and you think you can disqualify it because there's a program overlaid on it, well, should we give a reasonable accommodation? And I think at a minimum, a reasonable accommodation is appropriate. because again, a whole bunch of Smith College students can live there. So why not let disabled children live there that need access to a program in a residential neighborhood? Um, the driveway, I mean, the common driveway is just it's just irrelevant to this board's analysis. I don't think this board is here to consider the rights, duties, obligations with respect to this driveway and who may use it or not use it. The land court's deciding that. I don't think what the land court has decided so far has any binding effect upon this board. I think the board can make its own decision, but I do think the board can consider what the land court has done so far, which is the land court has considered the population disabled based upon what it knows, because the only information provided to the land court is the same information provided to this board, which qualifies these potential residents, these children, as disabled, because the affidavits of my clients and the CMR discuss that these children, in fact, have mental or behavioral health issues that requires them to live in a living environment outside of their home. And if you can't live at home, then you're disabled. I mean, that's the ultimate handicap. I am unable to live at home because of what I'm experiencing in life. That's the ultimate handicap. So these children are disabled. And I think, the court's finding in that regard should influence this board to find that if this board deems a reasonable accommodation appropriate, because we don't meet the definition of a single housekeeping unit, that the children are considered disabled. And I also think the board should consider the fact that the court found that the use is residential. The court views the fact that there's a program overlaying where these children live does not mean it's not a residential use. The court said it's still their home. It's still a residential use. And, there's some case law cited in my papers and in the court's decision of similar type situations. So I think that's all I have for right now. Obviously, I'm willing to entertain any questions, and I know we've already been here a while. Thank you.
Thank you. My thoughts for the board, it's 10 after 7. One, if people want to take a short break, we could do that. But two, maybe going forward might be to just allow Attorney Glover to give any brief response, and then I want to make sure we give people, members of the public here, an opportunity to be heard, those that want to be, rather than just those who are listening. I will ask Attorney Tyne, only for the benefit of the neighbors who are here. Has your client, the owner of the property, operated a program like this before?
I think I think him or his partners or his group operate facilities treating other types of mental or behavioral health issues, but not one licensed under this program for adolescents. I think they have adult treatment facilities, I think, for substance abuse.
Okay. And again, this doesn't necessarily relate to our decision-making analysis, but
understood.
For the benefit of the neighbors, I know that if I were a neighbor, I would want to have an opportunity to ask these questions. The staffing, can you address what the staffing is going to be? Again, doesn't necessarily relate to our decision, but just for informational purposes.
It is in the affidavits which have been submitted both to the land court and to this board. There's staffing at all times.
24 hours.
There is. The staff does not sleep there, but they're on shifts, and there's at least 2 people there at all time, is my understanding. And there's probably more people there during the day because they're cooking meals and doing other things,
Okay. Okay. Board members, do we want to, I know I'm trying to be sensitive at this point to people's time as well, but do people have a preference to take like a 4-minute break, or should we plow ahead and then revisit the question of a quick break? I could go either way. Want to plow ahead? Keep going?
Keep going.
Okay. Attorneys, are you okay with that? Or just both of you?
Yeah,
Okay.
I'm fine with it.
Good.
Attorney Glover?
So, Attorney Glover, if you want to just maybe have any brief initial response, and then I do want to make sure we hear from members of the public who want to address the board.
Sure. Again, this is a little scattered because I'm just responding to several things. I what stuck out to me the most was the phrase that if the board were to find this can't be a single housekeeping unit or people living in a single housekeeping unit because they have mental health issues, that would be discrimination. Of course, that would be discrimination. That's not what my clients are asking. My clients are saying, is this facility a uh, you know, a housekeeping unit? Is it a home? It may be homey. It may be intended to make residents feel comfortable, clients feel comfortable, and have been sort of therapeutic benefits. But the fact that there are these people driving up and down the driveway for a variety of purposes, I don't think you can say, well, they're only driving there because they're disabled, so it's discrimination to say, I'm going to make numbers up, 40 cars and trucks is worse than 10 cars and trucks. I think that's really conflating it. It's the volume and size.
What about the point he made that if there were Smith students, there could easily be 16 Smith students, and each one of them would probably have to have a car, at least more than the majority of them, and they'd be coming and going more than kids would be coming and going.
Yeah, I can't really speak to that hypothetical. I mean, I know that students often have cars. I can't speak to sort of the imaginary hypotheticals about huge numbers of people living up there. And I want to circle back to where Attorney Time was near the end, which is the question is this a, single housekeeping unit? And I think a bunch of roommates together would qualify as a single housekeeping unit, all other things being equal. This is a facility where people go for treatment and sleep overnight for short stays. It's not somewhere people go to live and have treatment. And the difference is because this is a rural residential neighborhood. Northampton doesn't permit, any of these larger types of uses by right in that district. People sleep overnight and have a homey environment in a hotel, in a lodging or boarding house, in a bed and breakfast. I mean, those factors that it's homey and that there's a kitchen, a single kitchen, and that people congregate in areas, nursing homes. I mean, that doesn't answer the question as to whether this is a people living as a single housekeeping unit.
So are you saying that if in fact there was something in the licensure saying everybody has to stay a minimum of 15 days, it would then be a home? I don't understand this.
No, I'm not saying that at all. I don't think it's 15 days or a month. I think is what is the fact that on happenstance, people may stay shorter or longer periods. I don't think it makes a difference. The fact that there's this 15-day threshold, again, I don't, for Northampton's bylaw purposes, it makes no difference. The first question is, does this fit within the bylaw without regard to licensing definitions and things like that? Because those aren't relevant to the bylaw. And then the second question is, if it doesn't, if the board found it didn't, then did the board need to make any, well, is the board, if the board were to say no, would it be treating this facility differently from the same type of facility in a rural residential district? Did you do it differently before? If you skip over that, then the next question under, if it qualifies under the FHA, is going to be, is there some accommodation? In this situation, there's no accommodation. It's black or white, it's on or off. There's no sort of get a special keyboard because my paralegal has carpal tunnel syndrome, so I'll pay more for a keyboard or a chair. There's no partway accommodation. And in this particular case, the reason all of the traffic and everything comes back to the accommodation issue is that it might be an accommodation to say, okay, yes, in situation A, location A, but in location B, no. And that's because this is a private driveway that's shared by just a few families. It's just not the appropriate place for that type of accommodation. But that's if you sort of down the road in your decision-making process. The land court, I just have to say, and I know the board really doesn't care about the land court that much, but I stipulated for the purpose of the argument that we would call the clients disabled. There's no like factual finding that they're disabled. That was assumed by everybody to save time and for the purposes. And the court made no finding about residential use under the zoning bylaw. Again, it's not relevant to the Northampton zoning bylaws.
The thing that bothers me is we keep going back to the driveway and the amount of traffic. And nowadays, one of the big things going on is, I'm just going to use an example, elderly women, widowed, 75, 80, might have had a stroke, might have had a heart attack, selling their homes and living together in a place like this with multiple bedrooms. Lots of social workers coming in, lots of home nurses coming in, and nobody would object to that.
Right, because they're living there.
One of them might die. One of them might decide that she hates Annie and moves out.
Yeah, but that's different, right? That's different. That's people who are living there, just like I'm living in my home right now, and I could die tomorrow or move out or sell it. But
the point is that the traffic is what you're using as an I don't want to use the word excuse, but the traffic is what you're using as the problem, and that would actually generate more traffic, but yet you say that's okay.
I'm not saying it's okay. I'm saying that it is, in terms of actual impact of traffic, we don't have numbers from the types of uses you're talking about or the other use in front of us right now. We are getting numbers. My clients are getting numbers. We don't have that right now, but I'm saying that in terms of hypothetical other uses and the amount of traffic and how that would physically impact the driveway, I can't answer that question right now. I'm saying the use that is here is not a single family residential use because it's not a single housekeeping unit.
I have a question that goes to the transient issue, which I think is kind of core to this whole thing. And my question is going to Attorney Tyne. Basically, the two questions. One, is there an expectation that the person in the house is going to return to the home they came from, or somewhere else, but from that home? And two, is there a maximum stay? Because the affidavit from your Mr. Theriault, if that's how you pronounce his name, Theriault, says that it's going to be a few days to a few months. Is there a maximum stay allowed under the licensing for somebody to be there, or by the program itself? Because I've never seen more than 3 months. And I think, that certainty or lack of certainty around length of stay, it's almost akin to the definition of, resident, whether you're present with indefinite intent to remain, or is there something in the licensing or the program rules that limits the amount of stay, and then the person would return home or somewhere else? That's a question.
So I did look at the licensing, and I didn't see anything which had a required length of stay, a minimum length of stay, a maximum length of stay. I didn't see that. I didn't see that in there. So the only information I have is Dennis Thoreau, where he said, I think typical it's days to months is what he said. He's someone who
if that is based on,
I think it's just based on his experience.
Or experience with this kind of population.
I think it's based on his experience. I don't think.
And then is the expectation these people would return to their homes?
I don't know the answer to that question. I don't have enough information because I assume some of these children don't even come from their homes. They may come from a higher level of care. They may come from another situation. So I don't know the answer to that. I just don't have that information. I'm sorry.
Can I ask a quick question?
Sure.
Is this is the title of this place, is it a residential treatment center?
actually what it would be, what it's called under the license. I don't want to misspeak, so
The permit, the drawings that were attached to the building permit application call it Meadow Hill Behavioral Health. If that answers that.
No, there's something called a residential treatment center, and I want to know if this is one.
I think the CMR calls this a group care program, so the license calls it a group care program.
Okay, thank you.
Yeah.
But Attorney Tyne, your position is even if we were to, let's assume there was a maximum stay, and we don't see that, you don't see that anywhere, of 2 or 3 months, and let's assume we took that into account for lack of any other guidance under the ordinance as to whether this is a single family use. Your argument is, well, then we would just have to move on to reasonable accommodation.
Right. I mean, my position is that when the kids are living there, they're living there. It's their home when they're there. They have a bedroom, they have their stuff, they're watching TV, they're eating together, they're doing their programs, probably, schoolwork, and they're receiving their therapy because they have conditions that need to be treated. And my position is when they're there, however long that is, it's their home. And I think again, there's a if everyone there stayed a day, then I think there'd be a great argument to say, well, this doesn't qualify as a single housekeeping unit. You're not establishing any sort of, permanency if everyone is staying a day. But that's just not the nature of this type of program. The nature of this type of program is that people may be there months or longer.
Okay. Just a question, and I want to just dispense with it because it's out of left field, but ever since this application came in, I kept thinking about the Dover Amendment. When I used to do these projects back in the day, we would rely on the Dover Amendment, an argument that there's an educational use here.
I think
yes,
to qualify
Yeah.
under the Dover Amendment, well, 40A Section 3, Paragraph 4 is part of the Dover Amendment, that
Right,
discrimination paragraph that we're looking at. You're talking about, it might
the
be paragraph.
educational use exemption.
Yeah, but you also have to be nonprofit, and this is not a nonprofit.
Yes, good
So I
point.
think if they wanted to run a nonprofit and do the same exact program, then maybe this would be no argument at all.
Yeah, I agree with that. And I think it's important just in that context to note that this is quite definitely not a nonprofit. I've been involved in
No,
similar programs.
fine.
They're
Yeah,
extremely
I wasn't
profitable.
focusing on the nature of the ownership entity.
They mint money. Could I say one quick thing?
Sure.
That I think the question, I think the question wasn't clear, but I think these individuals, the clients, they are all children, and they are coming initially from home, maybe through a facility, and returning back to home or to a facility. But these are kids with families. No one's writing those checks from DCF. So yes, they have families, presumably, and homes they'll go back to. Summer camp is not someone's residence. It's not a home. They're there all summer for 3 months. I just think I just think that a group care program as opposed to a single housekeeping unit, they're very different things.
Okay. I think I'll open it up and ask, and I guess, Nathan, there's a way for people to raise their hand or otherwise indicate they'd like to address the board. Let's get some public comment here before it gets any later.
Thank you. Yeah, so two people, Alex Bowman and Louis Hasbrook, the building commissioner or building inspector acting as general in the public. Yeah, they had their hands raised, so I can ask Alex Bowman to unmute.
Okay, thank you.
Okay. Right.
Again, if you could just give your name and address for the record. And
Hi, Alex Bowman, Market Street. I don't know anyone here. I've never spoken to anyone about this project. I was just mostly interested in it. There's one definition within the the ordinance called an assisted living residence. It says a profit or nonprofit entity which provides room and board, and where the operator provides a minimum of 2 meals a day and assistance with activities of daily living for 3 or more elderly residents or persons with disabilities, as defined and licensed, or as may be defined and licensed in the future by Massachusetts general laws. This seems to be a much better definition for the use that's going on here, but I don't understand why no one has referenced this definition that is in the ordinance, and instead we're using a definition of single family residence when this is a much more fitting definition. Um, we've gone through everything here. They're providing room and board. They're providing 2 meals a day at least. They're assisting with the activities of daily life. It's 3 or more elderly residents. Sorry, not elderly residents, but people with disabilities. All of those things have been met, and I just don't understand why, an assisted living residence is not allowed by right in the rural residential district. It is allowed by right in other districts, but it's not allowed by right in the rural residential district.
I think ADL has a specific meaning. And that is things like, it's normally considered things like toileting and.
I'm reading you the definition from
I
the,
know, I understand, but you said for help with ADLs, right? Assisted daily living activities.
The daily living, yeah.
Yeah, that usually refers to like a PCA arrangement where people need help with mobility or toileting or brushing teeth or very, very basic day-to-day kinds of things. So I think, and it has come up in the materials that we received somewhere. I think I recall seeing that, but I think that has a very specific meaning that's different than what this treatment facility is talking about.
but why aren't we using the definition that matches almost exactly what the
Yeah.
use case for this facility is, and not trying to say, oh, well, does it meet this other definition that it's not clear at all. So I think the other part of it is that there's other definitions like halfway house that also, that one's close. There's the person living on site, which does not match, but this sounds like an assisted living residence. So I just want to be clear with that. Thank you.
Okay, why don't we'll hear the other comments, and to the extent the attorneys, it's really up to the attorneys if they want to respond to a question like that, and then we'll let them have that opportunity. Mr. Hasbrook, I think might be next.
Yeah, I will unmute Mr. Hasbrook. Mr. Hasbrook just let me ask him to unmute. He unraise his hand, but I'll just ask him to unmute. Mr. Hasbrook,
Yeah, he's unmuted.
yeah, okay. Yeah, you're unmuted, Mr. Hasbrook.
All right. My name is Louis Hasbrook. I live at 33 Laurel Park in Northampton. It's in the same neighborhood as Coles Meadow Road. And I'm here as a neighbor and not as a city employee. I'm part-time, still employed part-time by the city, but this is completely separate from it. But I do have a few comments. First of all, I don't think I've heard anyone read the whole of 40A Section 3, Paragraph 4, and I would like to, if that's okay.
Oh,
It's okay with me.
yeah, okay.
So notwithstanding any general or special law to the contrary, local land use and health and safety laws, regulations, practices, ordinances, bylaws, and decisions of a city or town shall not discriminate against a disabled person, period. Imposition of health and safety laws or land use requirements on congregate living arrangements, note the congregate living arrangements, among non-related persons with disabilities that are not imposed on families and groups of similar size or other unrelated persons shall constitute discrimination. Period. It's real straightforward. The Fitch, just as a bit of information, the Fitchburg case was not about disabled persons. It was about sober houses, and it was about a triple decker each, a separate dwelling unit that was put out. And beyond that, they had refused to put a sprinkler system in it. And part of the discussion at this SJC was that they weren't willing to do that. A little bit more, the general law 40A, related city ordinances and provisions in the state building code to ensure fire safety make it possible to allow emotionally troubled, behaviorally challenged, and disabled persons to live in the community like other families, as opposed to being institutionalized. The building code has a very specific set of criteria for congregate living facilities, 16 persons or less, that involve means of egress, fire alarm system, smoke detection, sprinkler system. But it's called R for residential use. It's residential. It's not institutional, which is the other aspect. Assisted living facilities are licensed by the Office of Elder Care Services, and so I think not relevant. There are several places in Northampton that are similar to this. There's one on Burt's Pit Road, which is almost identical. It's an older, large house, been converted. They recently added rooms in the basement, but it's for troubled adolescents. And I've put a lot of time and energy into trying to protect the rights of disabled over the years. And I'm proud to live in a community like Northampton that supports disabled persons to the extent that the city does. Thank you.
Thank you. I think I see Mr. Rice is.
Oh yeah, yes. Sorry, 1 second. I was typing. And yeah, he's the. Yeah, I've asked you to unmute, Mr. Rice.
Yes, can you hear me?
Yes.
Yes. My name is Jim Reese. I live at 108 Coles Meadow Road. We're one of the 6 families that were in this association. My property has an easement going up the road. Couple points I'd like to make. I was the director of the Amherst Shelter, which is a 10-bed short-term shelter in Amherst for many years, and then later became the associate executive director of ServiceNet. So to address a couple issues, I cannot imagine that most of these kids are, which we totally support. My whole career, 40 years, was devoted to these kinds of disabled people. The market that this company, for-profit company, is trying to market to is for people who, unfortunately, and there is a need for this, waiting for a psychiatric placement or a step down from a psychiatric or residential program or a foster home. And so the issue of whether this is a longer term residential, it's not. As they've said, it's days or weeks. So it is, in my opinion, as much as I support these kind of programs, this is not that kind of a program. The second thing is there's no way this is a treatment program for longer term residential. This is adolescents who cannot be in their home require more than, a few weeks or a few months. So I think that's not the case that is being addressed here. Let me see if there's any other points.
Can I
I
just
know I have a feeling this is.
Can I ask how you know this? I mean, already Attorney Tyne has said he's not particularly familiar with all of the details for what this program will be, but you're coming in saying that you know that it's going to be these things. How do you know this?
What he said and what's in the documents is he said this is a facility for days or weeks. So I do not know, but what I'm telling you is from my experience. from being in the field here is I think the market that they're appealing to is what I just said. So this is not a longer term residence like a halfway house. Um, and the other point I'd like to make, which I know is a more minor point, but I think still significant given the zoning implications, from running a facility such as this, which I did for many years in Amherst, I estimate, and I could give you the specifics if I want, but I estimate 120 visits per week up this driveway. And I could break that down specifically if you're interested. So let me know if you are.
Yeah, I don't think that's necessary, but we'll take that opinion under advisement.
Mm-hmm.
Anything else, or we could move on? Is there anyone else who would like to address the board and on this matter who's present?
Yeah, David, oh, wait, Alex Bowman, has his hand raised again.
Oh, I assumed we had already heard from him, but
It's a newly raised, hand.
okay, because Mr. Rice's hand is also up. Mr. Bowman, did you want to speak again?
Well, I can, Mr. Rice is still, okay,
Oh,
Mr. Rice unraised his hand, so
oh,
Mr. Bowman still has his hand raised, so I think he wishes to
yes,
speak.
yeah, go ahead.
Oh, wait, is Mr. Rice speak? Oh, Mr.
No,
Reese,
Mr. Bowman.
no, I'm gonna unmute Mr. Rice. I think he's done speaking because he unraised,
Right,
he lowered his hand, so,
right. I do
uh,
see
yeah,
Miss Ball,
Bowman,
but
Bowman.
Mr. Bowman, your hand is up. Did you
Yeah,
still?
yeah, I'm gonna ask him to unmute. I haven't because of Mr. Rice. Okay,
All right,
Mr.
I just wanted to give my credentials. I was previously on the special permit granting authority of the town of Sandusfield as a as a member of the Board of Selectmen. So I just wanted to provide the context for my expertise here and understanding why to use the use that most closely meets the use that's being proposed, rather than trying to shoehorn the use that is not close to the use that's being proposed. Um, and I just finally, the one reason why I think this is being confused is that it was originally as a special permit was just proposed sorry, um, for the original zoning permit application, all it said was a residence for people with mental disabilities. And it did not specify that it was a licensed facility. So I think the most important thing here is that this is a licensed facility. We don't see many uh, single family homes that require uh, licenses. So I think that's something that's important to take into consideration. Thank you.
Thank you.
Thank you.
And then, so if we could, there you go. And then I see another hand up, Ms. Ball, I think.
Yeah, I'm gonna,
Hold on,
okay.
give us a sec.
Yeah, I'm gonna unmute Miss Ball. Okay, you can unmute yourself.
Oh, I guess, there we go. Okay, yes,
Yeah,
ma'am.
hi. I couldn't get my hand to show up somehow, other than literally, instead of iconally. Um, I just, in terms of the purpose of this home,
I'm sorry to
I
interrupt.
don't,
Would you mind identifying yourself and your
oh,
address?
okay. My name is Eileen Ball, and I live at 120 Coles Meadow Road. Within the six-house complex, although further away, of 74 Coles Meadow Road. Um, I'm not sure why someone that buys that an organization, LLC, whatever those are really called, but I don't quite, I mean, I wonder why, if the intention is to make money, it's a commercial organization, for profit. It's commercial, and I don't understand how, if the intention is to set up a for-profit money-making situation, I don't understand why that isn't somehow prohibited. that's the primary intention of the
Right. I suppose you could say that
organization
about
that bought
any,
it.
I suppose you could say that about any landlord that invests in a piece of real estate to rent it out, but I understand this is a little different than that. So um, we could, I suppose we could see if Attorney Tyne wants to respond to that. But anything else? Or Maureen, did you?
I would be curious if Nathan could just weigh in on just that factor since it's come up from some of the abutters letters that have been submitted that this is a for-profit. Are there any factors that in rural residential that would come into place to not allow a business, a for-profit business?
So in general, it's a heavily residential district, but not specifically this one, but there are some other limited types of commercial uses allowed with different type of permitting. I can quickly, if you don't mind me,
While you're looking,
sending,
Nathan,
yeah.
isn't the whole point that it's it may be an owner that's operating for profit, but at least the owner's argument is it's a residential use.
Right.
Yes, and so yeah, in actually a rental arrangement, which is very common, is not restricted. Even if the owner doesn't live there at all, but rents out the whole property for their profit and
Ex-
income, that would be considered a allowed use in all districts.
Okay.
The
It
rental
goes to the
owners,
crux of the
yeah.
whole analysis. Is this a single family residential use? And if not, does an accommodation have to be made because the occupants have a disability? Does everyone agree with that? Am I missing anything there? Um, does that make sense, Nathan?
Yes, so that is the crux of it. I mean, even with the commercial, the mental health program overlay, which is commercial also here in this case, is just still overall a single family use. I mean, also another factor to consider is in this zoning district and pretty much all other residential zoning district, um, again, a different case, but the home business use are allowed by right. And if you have a more intensive home business use, it's still allowed by right, with a special permit from the ZBA. And just to list a couple of different potentially commercial uses in the district. Family daycare, that's allowed by, I think, right, even at the state level. Family daycare, temporary events, agricultural use, also a solar farm. Solar farm is allowed with certain more types of permits. Educational use, nonprofit, religious use, daycare, school-age children care program with the planning board site plan. Um, let's see. And also for historical or religious buildings, there is a reuse allowed for live workspace and on and so on. And I believe there's a year-round greenhouse. Sorry, I'll try to be quick.
So,
Year-round
th- so,
greenhouse.
so
Yeah,
there are numerous other commercial uses that
yeah,
actually are allowed
yeah.
in residential districts.
Yeah, but
Right.
typically with at least a site plan, one notable thing is open outdoor marijuana cultivation. Um, Also almost there, just there's also commercial stable kennel that's allowed with the special permit, bed and breakfast. Yeah, and I mean I can go on, but basically in the rural residential attachment, zoning attachment, I believe that's zoning attachment number 4. And yeah, those are some of the allowed types of commercial uses. It's not purely residential, although it might require certain
Yeah.
types of permitting.
Thank you. Thank you.
I think
Just in terms of dotting our i's and crossing our t's. And I don't think the home business situations apply because those generally involve the property owner or the home business owner residing on the property. But there were several others that you
well,
cited that may not be the case. Yeah.
Mr. Bowman has mentioned one, but I think I heard Elizabeth say that that type of disability assumes that there is a inability to a loss of daily what is it?
Yeah,
Daily
it's activities of daily living, which is traditionally defined as your very basic, activities.
more basic than I think the clients that or the occupants that
Yeah,
we're
yeah,
hearing about in this program, which who are able to brush their teeth and do their own toileting and that sort of thing. And I just for the record want to make I'm not sure Mr. Bowman heard you say that, Elizabeth, that that's what distinguishes the classification of use that he is referencing. Otherwise, he's quite right. Um, and then to Miss Ball's point, there are numerous commercial uses that are allowed. And again, arguably, any landlord who buys a property and rents it out is doing it to make money. Any other comments from the from
I would like to comment, David, as a physician, I can very clearly say activities of daily living mean toileting, dressing, bathroom, very basic functions is what activities of daily living mean.
so that distinguishes the item that Mr. Bowman was pointing out.
Yeah.
Thank you. Appreciate
I don't know how to raise my hand. Can I just make 3 quick comments?
Yeah, first of all, let's just make sure there isn't anyone else from the public who hasn't had a chance to speak. I'm seeing Mr. Race's hand up again and Mr. Bowman. Is there anyone else who hasn't spoken? Or I only see three others, so I guess. Okay, why don't we hear very quickly from Mr. Bowman, and then it looks like Mr. Race's hand is up as well.
Yeah, Mr. Race raised his hand first. I will enable him
Okay, well,
first.
then
Yeah.
then
Yeah.
Mr. Bowman, just sit tight. We'll hear from Mr. Race first. He raised his hand first.
Reese.
Yeah.
Reese, I'm sorry, I'm getting it wrong. I'm sorry, I apologize.
Right. Yeah. Yep.
Thank you. I appreciate that. I have a feeling this is obviously a very complicated case, and the board has given a lot of hours to this, and I really want to, as volunteers, want to appreciate what you've done. I just want to emphasize that I have a feeling this is a complicated gray area, and I assume in the back of your head, maybe there's a concern about the city being sued if you rule in favor of Jerry Hinkle and Mirwan. But I'm just hoping you guys do the right thing. I know you don't want to incur costs for the city, but just hoping that you're able to consider everything that's been said. Thank you.
Thank you. We're definitely trying to do that. And I'd also point out that I've been doing this now, I believe, 25 years and over 20 for sure. And somebody's going to sue us in many of these cases. Hopefully not this one, but if it's on one side, it's the other side. So we try not to let that influence our doing the best we can to come up with a decision that makes the most sense to us. But I appreciate that. Mr. Bowman, you had something else?
Oh, yes, and I haven't
Oh,
unmuted
we have
him
to,
yet.
yeah, we have to
Yeah,
make
give
the
me.
switch here.
And Mr. Reese, Mr. Reese, are you done speaking? Because your hand is
Yes.
still raised. Okay, okay, great. And I'm gonna unmute you. 1 second. I'm gonna mute you.
And then after that, we'll hear from
Yeah.
Mr. Hinkle. His hand is up too. But
Yeah.
first, Mr. Bowman, just
Yeah, Mr.
Jerry
Boma. Yeah,
Hinkle.
okay. Mr. Boma, you can speak.
I'm just trying to follow up on the question about ADLs, which I believe was brought up. And, the ADLs that are happening within the facility aren't really about the use of the facility. Whether or not ADLs that are happening within the facility are happening or not, that's not really affecting the use and which use this use most closely matches. So I just, I think it's really important to look at this use because it is almost exactly what matches here. And I think that's what we're trying to look at is use. How is the building being used? And there is an idea of what a single family residence is and what a two-family residence is. And then there's this definition and almost everything except for this one little tiny thing about helping people with their, what they're doing on the inside, going to the bathroom and showering, that, they're getting a similar help.
I can only assume that that distinction is the reason that Attorney Glover has not raised the argument that you're raising.
Okay.
because it would be hers to raise, I believe. Yeah, Nathan?
Yeah, just for clarity, would it be helpful for the board and the public if I share the screenshot of the ordinance about this assisted
Well,
living
I
room?
would I would defer to the attorneys if
Okay.
they want to make an argument based on a
Right.
different section of the ordinance. I think it's incumbent on them to do that. I think that's beyond sort of our scope here, especially when we have Attorney Elizabeth Silver telling us that that is the distinction, that that the application of that section of the ordinance necessitates a failure to be able of an individual to be able to attend to those daily living activities.
And we also have a physician, Sherry Taylor, who's
And Dr. Taylor. But Mr. Hinkle, if maybe we could hear from, I don't think he's had a chance to speak.
Right. Yes. Okay, 1 second.
Thank you. I didn't know if I could speak
Oh,
other than through my attorney, but I wanted to clarify a couple of things. First, in terms of this type of facility, so I am the father, my oldest daughter went through many years of heroin addiction. And I, she was in a similar-ish facility on a couple of different occasions, and I would visit those facilities. My 33-year-old daughter is now in absolutely fabulous shape. She's recovered 7 years. I personally am very grateful for the existence of these treatment facilities or whatever it is you determined that it is. So I just wanted to make that clear. In terms of harm, I have a younger daughter. Me or my wife do walk her down that road every day to school, to the bus stop on Coles Meadow. And it's not a broad, it's a driveway. And it's a driveway snaking through the forest with everything that Alex described. If a car comes on the road while we're doing that, we have to find a way to get off the road. There's not room. There's two pullouts, and it's 3/8 of a mile to 74 Coles Meadow. There's two pullouts. So we have to find a way. We generally have to get off the road. So when you see the emails about the possibility of us buying the home and renting it to Smith students, the, you know, first of all, we weren't going to be able to do that. And we tried to come to terms with God. If we did, what on earth could we do to it? So that is something that we pursued. Primarily what we did was I called Smith to ask about them buying the home for their own residents. And it was about volume. It was about, there certainly wouldn't have been 16 tenants. There probably would have been less than 8, but we never got that far. It was just about, because in going to that facility that my daughter, it's not just staff and, residents. We got to visit once or twice a week. And I'll tell you, on visitation day, everybody came. And that's another 16 or more cars. I don't know. Maybe that's analysis that we'll present to the land court. Anyway, thank you for listening. Thank you for your volunteer work. I do a lot of that myself, and I'm clear that your expertise is making a real difference in this instance, and I appreciate that.
Thank you.
That's it.
Thank you. If there's no one else from the public to speak, I'm not sure there's anyone left. We will, I guess I'll just ask the board members if they have any more questions for the attorneys, and then if not, we could entertain a motion. I mean, in terms of follow-up, it sounds like at first I was wondering about this new SJC case and whether we needed the time to look at it, but I think it's been distinguished a couple different ways here, unless Attorney Glover feels strongly about that. Same with the land court decision. I'm just thinking from my list, is there anything that might make me want to say, rather than close the public hearing, let's keep it open. But
I
because
do have one
yeah,
question related to definition of the residence. At one point, Attorney Glover refers to it as a lodging unit. This was in the March 13 letter or complaint. And then later in the June 17th appeal refers to it as a halfway house or community residence. And I guess I don't know if you were searching for something alternative which you wanted to settle on and what your citations would be for those in trying to categorize what this is, characterize what it is.
Yeah, I'm glad you brought that up. Thank you. I was actually wondering if I should submit a letter just right before this, just to clarify. The nature of the program, at least to me, has not been entirely clear. It's evolved from that first zoning permit to the land court action to information that I actually got from the building inspector that I didn't know. And then information provided through Attorney Tyne. So there's been a real evolving understanding of what the nature of this use even is, whether it's going to be licensed or not licensed. I'm still not sure what the use, I mean, we understand the parameters. It sounds like the applicant doesn't know what the type of population that's going to be served. I don't think that's relevant to the zoning definition at all.
Okay.
But in terms of what it is, I've had a real evolving sort of trying to understand the details.
Okay. But you're saying it's not really relevant.
I mean, I think it's whatever it is not living people living in a single housekeeping unit. So
okay. All right. Thank you.
David, I have a question that really deals with what our role is in the zoning board, if you don't mind my asking that. So let's just theoretically say that we do agree that this is a single family use, not single family use, but a residence. But the objection is that this is affecting safety on this driveway, this shared driveway. Is there any way that we can say we agree this can be there, but there has to be some accommodation for them to make the driveway more safe?
That's a good question. And I think it goes, yeah, Attorney Glover, do you have a thought?
I'll just take a crack. Probably Attorney Tyne and I would agree on this. I think that the initial question for the board is, is it permitted or not? Just without regard to traffic or anything like that. Is it fall within a permitted category in the rural residential district or not? And then I think I agree with Attorney Tyne. Then your next step is going to you sort of end up with, is there if not, is there some accommodation that would need to be made, assuming this is a disabled population? So I think as to your first question, I don't think the board considers impact or volume. I think the board just says, is this, in terms of effect, the board just says, is this residential use or not? I don't think that you consider impact in terms of traffic.
It's not like this is a special permit where we
Right.
can assign conditions to
Okay.
our approval. We are simply being asked to issue a decision as to whether the building inspector erred or not in his determination that this is a residential use and that it would be and in order to avoid discrimination, it is allowed. So I think I'm saying the same thing, and I assume Attorney Tyne agrees with that analysis.
I do agree, and I think the land court case is very focused on the use of the driveway and what can or cannot happen on that driveway.
Right.
So I
Yeah.
think that's up to the land court.
Yeah. It would be different, Sherry, if, like, as I said, if this were an application for the issuance of a special permit,
Special permit.
where,
Okay.
we're in a position to put conditions on the permit itself, like changes to that driveway. But that driveway really is personal property, subject to an easement under a private common driveway. I assume common driveway maintenance and reciprocal easement agreement, something like that. And so we don't in this context, we don't really get involved with that.
Okay.
So an extension of that question is, were we to theoretically decide by unanimous vote that the building commissioner erred in granting the building permit as a, by right, satisfying the residential family condition, what would happen next?
That's also a good question. Well, it would mean that the building inspectors or zoning enforcement officers' decision to approve I assume it was a zoning permit application, was incorrect, and therefore that would at a minimum delay or prohibit the property owner's ability to proceed with the project as proposed, absent some other permitting action. Again, I'm looking to either Nathan or the attorneys to just Nathan, does that make sense?
Yes.
If we were
If
to,
I may
yeah,
speak at this
please.
point,
Mhm.
yeah, this my opinion. There are a couple different forks at this point. So basically, what the board is doing is in this case, so the board's power is you can hear appeals for administrative decisions at the lower level, specifically building commissioner. So in this particular hearing, what has happened is the building commissioner issued the zoning permit, and then the appellant they asked for a zoning enforcement request, and the building commissioner denied the zoning enforcement request. And specifically, although it's all related, technically you're not hearing the appeal of the zoning permit, but the subsequent denial of the zoning
Yes, of
enforcement
course.
request.
Thank you.
So
Yeah.
now, what would happen is, like Maureen asked, if the board unanimously agrees to overturn the building commission decision. Either, again, my opinion, but from my understanding, either the subject property owners at 74 Closure Meadow Road, they can then take it to the next appeal as allowed by M040A17, kind of, oh yeah, 17, to the higher court, the land court or the Supreme Court, or not the Supreme Court, but one of the higher courts, or the the property owner at 74 Coles Meadow Road, they can just decide to agree with that overturning, determine basically that would be basically getting a zoning permit denial, getting a denial of the zoning use. And then they can decide to modify the use or pursue some other ways to use the property in some other way that is allowed by zoning.
Right. Yeah.
Yeah.
Thank you for that clarification. I
Yeah.
left a step out. We are being asked to decide on the the building inspector's denial of the applicant or appellant's request for enforcement.
Yes, zoning
But
enforcement.
either way, if either party doesn't like what we do, they have recourse. They go to either the land court or the superior court, I believe,
Yeah, yes.
for a review of our decision, which is that's how our justice system works. And so it's not the end of the road if necessarily. That's but those I think are we now, because it's really a very good question. I'm glad you asked, Maureen, because we want to be clear about
Right.
implications of both decisions might be.
And it was based on also wondering if it would come back to us as a special permit request or something, if it would.
It could
But it
if
sounds like that would not, like Nathan was saying, it would go the next level up rather than
first,
coming
yeah,
back to
first,
us.
and then it would only come
Yeah.
back to us for some sort of permit if the property owner gets the point based on the various rulings that it cannot proceed as intended and needs to find a
Okay.
different way to
Right.
develop the project with subject to some other permitting, I guess. But that's down the road for other people to decide before it ever
Right.
comes
Yeah.
back to us.
Is there a standard at which we're looking at whether or not the building commissioner erred? Like, abuse of discretion, clear and convincing, or is it just, I'm not sure how to look at this.
Another very good question. Nathan, do you happen to know if somewhere in the ordinance
Oh,
there's a standard,
Attorney Glover just
or one of the attorneys has
I was good
had
if
input?
Nate,
Please.
so I think this board just makes an independent determination of its interpretation of the zoning bylaw. Whatever you decide will carry some weight if there's an appeal of your decision. But at this point, you're just deciding for yourselves. You reviewed his decision and his reasons and heard evidence and arguments, and you make a decision about whether or not this is a permitted use.
Yeah, that makes sense to me. I don't think I've ever seen like a standard stated for sort of standard of review that we apply to a decision. Nathan, I assume you're not aware of anything. I don't really want to start digging into the ordinance right now.
Yeah, I apologize for not knowing the full detail, but my basic understanding is basically so the building commissioner is the initial zoning administrator. So obviously we all rely on the same set of state and city zoning laws. And I guess in a way, one way to question this is that the zoning officer, the building commissioner, his interpretation that led to issuing the zoning permit was in error. So based on that, the board's interpretation of the zoning ordinance differs, so that I think the matter, yeah, basically you need to determine that, was that interpretation error?
Right.
That's helpful. Thank you.
There may not be a specific standard of review, like clear and convincing evidence or reason, whatever. So, again, we're not a court of law. We're just trying to apply the ordinance as best we can.
My last question. I'm sorry, but I do need to take a very brief break.
Sure. Just 5 minutes, 3 minutes, or just whatever you need.
3 minutes. 3 minutes would be
Okay,
great.
so we'll take a 3-minute break.
It's a lot of water. Okay.
Yeah, no, I
All right.
I relate.
Right. I'll just count for 3 minutes. 3-minute break.
Yeah, and
And
four.
we have a 4. Okay. Yeah.
Well, I mean, we'll come back in 3, and if we'll wait for anyone
Oh yeah.
another minute.
Yeah.
Let me just.
There's somebody with their hand raised, so we can come back to that after
Okay,
4
we'll come
minutes.
back to the raised hand.
Right. Okay.
Let's see, is everybody back? Everybody accounted for?
I think so.
Maybe
Attorney
not
Tyne,
Attorney Klein.
maybe?
There he
Yeah.
is.
Hi.
Right.
All the board members here.
Let me check.
There's Aaron. One, two,
Yep.
3, 4, 5, 6. Okay, I think that's everyone. So we'll continue. Let's see, where were we? I think we were starting to, or at least I was starting to talk about whether we're comfortable with a motion to close the public hearing. Oh no, Miss Ball wanted to comment. She has her hand raised, Nathan.
Yes, and before I let her let her speak, there is a very brief criteria resource in MGL 48 Section 8 about the appeal criteria. If you want me to, I can read it, or we
Is
can
it
just
if it's brief? Is it brief?
Yeah, yes, it's very brief. It's literally like two
Oh,
sentences.
please do.
Yeah, so so people, people may appeal. Who are agreed by an order of decision of the inspector of buildings or other administrative official in violation of any provision or of this chapter 48 or any ordinance or bylaw adopted there under. That's literally it for criteria at the state level.
Okay.
Thank you.
Thank you.
And I will let
And we'll hear from Ms.
Ms.
Ball,
Ball speak. Give
and
me one
then
second.
try to wrap up.
Okay.
So
Okay.
you just have to unmute yourself, Ms. Ball.
Yeah. Yep.
Yeah, got it. So it's a question. If the definition of what connotes or whatever a family residence actually is in a rural residential community, if there's so much ambiguity in that definition, is it possible that can the group send it back because there isn't enough information to deny an appeal because it's just not that clear, is that something that can happen? Like,
I think
you know what I mean? If
it's a good question. I think in my mind, we have to make a decision. For future reference, if people want to go to their city councilors and say, or to Nathan's office, which would still have to go to city council for an amendment to the ordinance to say, look, this needs clarification. We went, we had a very tough time in this particular case. Then as far as I know, the only scenario would be we have to make a decision on this one, but for the future, it won't help with this one. Perhaps it warrants the attention of Nathan's office and the city council in terms of consideration of some kind of amendment to the ordinance to clarify this question of several of the questions that have been raised during this hearing. But
so it's
I don't think we can, we have an obligation to render a decision under the ordinance with what we
but the
have.
decision is whether or not to abide by the denial of the appeal or to
Whether to,
suggest that the appeal goes through, right? It's to get an opportunity to appeal,
well,
right?
either way, either party will have another opportunity to appeal the decision we make. So it's not
Okay.
the end of the road. Now, it involves going to court, which, we all know what that's like, but it is a means of it's a form of recourse for either party. What about Nathan? Did you have something? Did you? No.
Yeah. Would it be okay if I try to briefly answer some of the concerns raised just now?
Sure, for sure.
Yeah, so I guess some of the questions about this hearing is, what defines single housekeeping unit, what's a family, and also what are the state laws that may supersede anything that's locally restrictive, and also lastly, the impact of certain uses. So first of all, even though the zoning ordinance itself might not like greatly specifically define the impact based on density or uses, there are some existing ordinance structures like minimum setback, minimum open space, which naturally limits the size of the house which then naturally limits how many can occupy. And although it's not at the city level, there are building codes and also the health code. Specifically, the one that the Attorney Tan hinted at is 105 CMR. Oh, I forgot I think 105 CMR, yeah, 105 CMR 410, minimum standards of fitness for human habitation. So that those state laws do limit just what's the minimum size of a dwelling can be, or how big can they be, and how many people can humanely live in a housing. So this big question is, even with the single family use, that's very typical. There are some conflicts possibly because of intensity of use that's allowed, but that's other neighbors might be unhappy with. And also besides that, there are some existing regulation at the state and local level that may directly or indirectly control the impact to a certain level. And thank you. I'll stop there.
Okay, thanks. I think that was a more specific description of something that Attorney Tyne alluded to when, in response to my hypothetical point for the sake of argument that could 50 people live there. It's like, no, there are other limitations for health and safety, and which of course the applicant has to adhere to no matter what, if it involves safety, and not the applicant, the property owner. So, okay, how does the board feel about a motion to close the public hearing? And as a reminder, that means after we vote to close the public hearing, we cannot hear any other input from anyone, public or even the attorneys or the property owners. Do we feel like we've heard everything we need to hear and are able to hear to make a decision?
I feel that way, but I also want to acknowledge that we have all fully read any of the written submissions that came in from over the
Yeah.
last week,
Thanks.
2 weeks, that
Thank
just to
you.
acknowledge that we have read those
Yes, thank you.
letters from
Thank you,
abutters.
Maureen. I think that's an excellent point. We have received and reviewed the public comment from Ball and Hell, is it just Helle or Heller?
Ball and Heller, who spoke tonight.
Also, Reis, Reese,
Mhm.
comment from Reese. And of course, we heard from him tonight. Actually, did Ball and Heller? I don't think Ball and Heller spoke tonight, but to your
That's
point.
Eileen Ball who
Oh, I'm
spoke.
sorry, Miss Ball, of
Yep.
course. Good. So
Yep.
we've also heard from them here.
Right. And their letters were very substantive. And I
Yeah.
just want to acknowledge that we have read them.
Right. Thank you. I appreciate that. I think that's good point. We appreciate everybody's input. Also, I think the attorneys were both very, very helpful. However, we vote. So do we have a motion to close the public hearing? And then after that, we can have discussion. We can have a motion. Is there any reason that people think we need to keep this open, the hearing open and
No,
go another day, or do we feel like we've
no.
heard everything? And
I
yeah.
feel okay to move forward.
Both attorneys, are you, anything else? We don't need any more summaries, I don't, but are you good if we?
I'm fine.
I'm satisfied. Thank you.
Thank
Thank
you.
you. Thank you. All right. Anyone, rest of the board members?
Motion to close the public hearing.
Okay,
Second.
Maureen, second. And because we're virtual, we need a roll call vote, please.
Okay, so Elizabeth made a motion and Maureen seconded. So by roll call,
Yes.
David,
Yes, in favor of closing the public hearing.
okay, and Elizabeth
Yes.
and Maureen.
Yes.
Okay, that's unanimous. So we've closed the public hearing. We're not able to ask or get any more answers or input from any other parties. But we can have discussion. Anybody want to start first with thoughts? I can jump in if people.
I'm willing to start, David.
Oh, please
Yeah.
share.
Please
I
share.
certainly don't think this is easy. I spent hours on this today, and it certainly is a very complex issue. But I think, to me, we need to simplify. And based on the bylaws I read, there is nothing to say that this is not a family residence. that this is not a group of people living together for a joint purpose in harmony, I'm hoping, in a way that certainly in Northampton, there are many, many different structures of families, all of which seem to work quite well, and people choose to live the way they wish to choose to live. These are children that aren't necessarily choosing to live here, but their parents and family feel that it's a necessary situation. And for the time they are there, this is their family. So I feel very strongly that based on the way our bylaws are written, and they can go to the city council and rewrite them. I don't have any problem with that if that's what people feel should be done. But the way it's currently written, I see no reason to feel that the building inspector or commissioner, I'm not sure exactly what his title is, erred when he made his decision.
Just say that last part again, please. That last sentence about the building commissioner.
Yeah, I do not feel that the building commissioner erred,
Okay.
made a mistake in the interpretation of current bylaw.
Okay. Yeah, I'm sort of on the same page, Sherry. And anyone else want to comment?
Well, first,
Uh,
go ahead, Maureen.
well, I feel the same way on the top level. I also, in listening to one of the people who spoke tonight, Alex Bowman, I'm feeling like we're testing the sort of spans of what our bylaws are actually providing us for guidance. And that's another topic for another day. But I think following, what we say we're doing, and I appreciated the neighbor Louis Hasbrook's input to support why, Northampton is generous and broad in our scope of what might constitute family. Like, I'm kind of proud of that, right? But I also recognize the challenges this will pose to the neighborhood, because they're going to have to be neighbors. And I hope that Attorney Tyne walks away recognizing that his client is kind of being tasked with being a good neighbor. And I hope they can all step up and interact on a positive level. But I do kind of align with Sherry's description of the case at hand for the reasons she cited.
Okay.
I think that's why I asked the question about the road, and obviously that is not in our purview here. But that was my point, is if in fact this proceeds as they wish it to proceed, this residence for teenagers, can they be good neighbors? Can they accommodate in a way that makes the safety issues more palatable for the neighbors?
Right. And there is the pending land court action, which may or may not lead to some ways to address that road. But again, as we keep saying, I'm not as sensitive as we are to the concerns that Mr. Hinkle raised about the safety of going up and down that road. I mean,
It's not our role.
it's I'm so sensitive to that, but I don't think we have I don't think it's within our purview. Elizabeth, did you have?
Well, first of all, I wanted to thank Attorney Glover and Attorney Tyne, because the amount of work and the thoroughness of their work has been amazing. It's been thorough, detailed, and incredibly helpful. And I sympathize with the abutters. I hear the argument about it being a short-term residence, and that does sort of flip what I think of normally as congregate living. Normally, I don't think of there being, a relatively short stay envisioned by it. So, that slowed me down. And I think that's a compliment to Attorney Glover that it slowed me down as much as it did. However, I do think that the building commissioner has the eye toward what our ordinances and bylaws mean and say, and I do align with what Sherry initially said and what Maureen and David have now said, that I do think it is going to meet the definition, and that the building commissioner has not erred in his decision in this matter. So that's what
and I'm glad you mentioned the point that we do, while we certainly have the authority and power to overturn the decision of the building commissioner, we're also aware of the fact that the building commissioner brings a lot of expertise. Doesn't mean he doesn't make mistakes, but brings a lot of expertise and background, and that we sort of appreciate that as well whenever he renders a decision. But doesn't mean we don't have the power to overturn it if it's clearly wrong. I also want to reference the comments of Mr. Hasbrook that or maybe paraphrase them. It's been so long ago that the concern about discrimination, it carries a lot of weight for me, because what we're balancing those considerations against are the concerns of the neighbors in terms of the safety of that road and so on. And it's such a hard one for us, and it's taken this long, and we're struggling this much because I think everybody is well intentioned here, but the need for facilities like the one that's been proposed, and certainly the need to guard against, especially in this day and age, as much as ever, in every way we possibly can against discrimination, is not only the reason that ordinance exists, but something that we have to guard against and be very sensitive to. And I'm not talking about the discrimination of any individual people here. I'm talking about the larger concern about defending against discrimination, because it can happen in really subtle ways that we're all susceptible to crossing certain lines. Again, I'm not saying that's the case here, but I'm talking about in big picture and the purpose of the ordinance. So to me, that carries a lot of weight as well, to balance against the other interests here. But I like what Sherry started by saying. It's really simple. I agree with Sherry and everyone else that as the section of the ordinance is currently written, I do not think that the zoning enforcement officer, the building inspector, erred in rendering the decision that he did. So I think we can have a motion and let people get back to their lives. Motion on.
Question though, did Aaron want to have any input
Oh,
on
I'm
this?
sorry, Aaron. Aaron, of course. Did you have any thoughts to share?
No, I honestly, I'll say really honestly, I'm grateful that I don't have to make a decision here. This is a very complicated issue in all directions. Starting with, my own experience with residential treatment programs and whether they are homes for the children that are in them. But I hear and agree with the argument that, if the question is, did the building commissioner make a valid decision? Yes, from everything I hear, I can't argue against that. But yes, I that's what I got.
Right. Thank you.
Thank
So
you.
specifically, I
Thank
think
you.
we're all agreeing that this proposed use does constitute a single-family residence, especially taking into account the fact that there is no limit on the number of people who live there. And after everything we've heard, uh, we agree with that determination that given everything we've heard about the nature of the programming that's going to exist and the fact that this is supposed to be a home, quote unquote, for these individuals while for the period of time that they're there. I think we agree with that. And we also agree that we simply cannot. We agree with the building inspector that the anti-discrimination ordinance, or I should say, state statute must be respected and applied. So I guess we could just have a motion on. I guess technically it's let's see. It's on the. So what we're doing is we're denying. And Nathan, help me here. We're denying the or we're rejecting the appeal. What's the verbiage? We're rejecting or denying the appeal of the commissioner's approval decisions for the residential health program at 74 Coles Meadow Road.
Yeah, I think it's a little bit confusing, all the negatives and whatnot. But I think one way to look at it is we can just clearly say yes vote means that you're overturning the building commissioner's decision. So you're
Because
agreeing with
we're upholding the appeal. We're
yeah.
up the appellant.
Why, to make it simple, why can't we just say we agree with the building commissioner's decision?
Or the building commissioner did not err in his decision.
Yeah.
But I
Okay,
think
yeah.
the decision is as to the appeal,
Yes.
not the building commissioner's decision. Is that a reason why? I think is that a reason why we need to say we? How did you say it, Nathan?
Yeah, I guess my view was that so the application before you is the appeal submitted by the appellant. So yes vote, so and typically you gotta vote yes or no or abstain. But yeah, a yes vote means that you're agreeing with the appellant. And with the unanimous 3 yes votes, you're overturning the building commissioner.
Right. So it needs to be a no vote.
So,
Yeah,
could I take a stab at this?
Sure.
Yeah.
Yeah. I'm going to propose that we deny the appeal of the building commissioner's approval decisions as requested by Attorney Glover for residential mental health program at 74 Coles Meadow Road, map ID 13001. Do we need more than that? And does that satisfy is that clear?
Maybe could we just add, and in so doing, we find that the building commissioner did not err, or maybe
Yes,
that's
that's helpful reinforcement. Yes.
Nathan, does that work
Yeah.
for you?
I think Attorney Glover wants to say something. I don't know if she can or not.
It's just procedural.
Okay, procedure.
It's just procedural. It's just that I think you need 2 votes. Nathan, I defer to you here, of course, but there's technically speaking 2 different appeals. I just so the
on both
decision is clear.
applications.
Okay.
Yeah.
Thank you.
Yeah, on LU 25-8 and LU 25-17. So yes, thank you.
So right. So we're actually at the moment, what we're deciding on is LU 25-8.
Well, I think we can do both of them. Can you not, Attorney Glover?
I would just reference both of them. I just wanted to be
I
clear
know.
for your own record.
So we deny the appeal, find that the building commissioner did not err with respect to
issuing a building permit, LU 25-8, and we are denying the applicant's zoning enforcement request, LU 25-17.
Okay.
Yes.
Okay. And I just want to add one more time that I thought, yeah, that both, I just want to add for the record one more time. I think it's been said twice that both attorneys, I think, just did an excellent job in this process. So, yeah, so I guess if that's it, Nathan, are you good with that? You're thinking.
Yeah, I mean, I think the overall motion is clear. I'm kind of mixed about so when you say yes, I'm sorry, I apologize for my confusion. So if you're saying yes, are you denying the appeal by the appellant,
Yeah.
Attorney Glover?
No, I don't think we want to say yes.
Oh, okay. Oh, okay.
We
Okay.
are denying the
Is that your
appeal.
point?
Okay.
We are denying the appeal of
Okay.
Attorney Glover.
Okay. So I guess if once I take roll call, what would you be stating?
Are you stating yes or no to this motion?
Oh, I see. Yeah.
I'm
Yeah.
confused.
Yeah.
Right.
Thank you, Sherry. Yeah. So
Motion is to deny the
the-
appeal,
the-
so it's a yes if you want to deny the appeal. And then the second part of the motion was a rationale saying that the building commissioner did not err in his
which
decision.
we don't really have to say, but
Yeah, that's right. We don't.
And David made a 3-point finding earlier, which I typed in, which said that we agree with the building commissioner that the anti-discrimination statute must be respected, and also I can add that the building commissioner. Yeah.
Well, I do think, Nathan, your original wording is what you were asking for, which is that we're denying the appeal. Like, are you saying we're okay with saying, yes, we approve the building commissioner's decisions? But because that's not the matter at hand. The matter at hand is we're hearing for the appeal
Yes.
placed by Attorney Glover. So I think we need to, for clarity's sake, deny the appeal.
so the motion is to deny the appeal.
The
Yeah.
appeal by Attorney Glover
Okay.
of the building commissioner's decisions, right?
Yeah. So okay. So my understanding, and actually to make sure, we haven't seconded the motion yet. I know
But
Maureen
repeat the motion before anybody
Yeah.
seconds it.
Yeah.
Yeah.
Maybe Maureen
And I think we want to add with respect to application LU 25-8 and
Right.
application
Okay.
LU 25-17.
Okay, so let me try again. I move that we deny the appeal by Attorney Glover of the building commissioner's approval decisions for 74 Coles Meadow Road, map ID 13001, record IDs LU 25-8 and LU 25-17.
Yeah.
And this is, well, to add, this is for the building commissioner approval decisions for the residential mental health program.
Programs at 74 Coles Meadow
Yes.
Road.
Right.
Yeah.
So to clarify, a yes
And
means you agree with denying the appeal, and a no vote means you don't agree. So you would want to vote yes, the way it's stated, correct?
Correct.
And I'll second it.
Yes.
Okay.
Okay. Was that
So yes
was,
means you
Deny.
the motion
Yeah.
to deny the appeal.
Yes.
Right.
Okay.
Right. Thank
Okay.
you, Sherry.
yes means you
Too
deny
many
the appeal.
negatives.
Yeah, so many
Right.
negatives.
I think we made it clear for the record.
And can I re-add what David said, that in so doing, the building commissioner did not err with did not err in his decision?
Yes.
Yeah.
Yes.
Okay.
And do we need to add in, based on Attorney Glover's reminder, the wording that goes with LU 25-17, that it's denying the applicant's zoning enforcement request?
So,
I think you covered it, but
Yeah, because we reference both numbers.
Yes, we did.
Okay.
and I
But
mean,
I said with
yeah,
respect to LU 25-8 and LU 25-17.
I mean, earlier,
Glover, is that okay? Do you think, is that going to give you what you need for appeal, Attorney Glover? Just the referencing the two different.
yes, I think that I just thought, to be clear, just for your own record, the board does need to make a detailed statement of findings if there's a denial of an appeal. Section 15, detailed record of proceedings.
Yeah, I mean, I'll say it again, but I thought I did. I said that we find that whoops. that the proposed use will satisfy the Northampton ordinance
That's currently written.
describing a single-family residential use. I mean, I had some other verbiage. Did you write it down, Nathan, about the fact that based on our opinion that the programming that has been described for this facility will constitute, let me get the exact language.
That does not need to be part of our vote, right?
It doesn't have to be part of the motion.
Right.
And I thought that I already said all of this. That
Yes.
Right. I mean, I think it's in the
I don't think
notes.
I don't think we're going into the use, David. I think we're going into the fact that, as described, it will satisfy the ordinance definition of single family or two-family residential.
right. You're right. Let's not use the word use.
Keeping
It will
away
satisfy the
from
definition of the ordinance for a single family or two family.
completely staying away from the use.
Yeah, I like that. I agree.
Because I have to say, apart from all of this, what Mr. Reese talked about in terms of it not being a treatment program and being stepped down and being for profit and all of that, there's a lot of what's going to happen in there that I understand the discomfort on the part of these abutters. So my vote here, that can't be part of my consideration in making the vote I'm making, but I think we need to stay away from what the use will be
I
because,
agree with you.
yeah.
It satisfies the definition in the zoning ordinance,
Yeah.
single family.
I personally think they should go in front of the city council and have that ordinance rewritten.
Right, but that would be prospective.
That's not our role.
Exactly.
I'm just saying, if I was the abutter, that's what I'd be doing.
So
You just
well,
can't
okay.
anticipate
Would be too little too late.
situation.
yeah, exactly. It's
This is when we find what doesn't fit right.
Yeah.
Right. Yeah, no, you can't anticipate everything. So we just need to go with this vote.
right.
So I had seconded the motion. Is there enough by way of findings here?
I know it's more time. I apologize for you. I thank you all for being here so long. I did write down David's initial findings with some additions you later added. It's 3 items from what I wrote.
Yeah, could you read those back?
Yes, I'll try to be quick.
And
The
I'll
board
ask-
found that the building commissioner did not err in his decisions. 1. This constitutes Northampton zoning ordinance definition of single family or two-family home, considering that there are no limits on the number of residents. 2. This is a home for these individuals during the time they are there. 3. We agree with the building commissioner that the anti-discrimination state statutes must be respected.
On the no limits, I think we might need to, there are limits within the, as you recognized before,
Right,
and
right.
Attorney Tyne pointed out, there are limits within the building code on space and how many square feet per person or per room.
but
So-
not,
But I think he said person.
which they have to adhere to no matter what. But in
Right.
the ordinance, the section of the ordinance, there's no numerical limit.
I'm sorry, okay.
But I'm not sure that's even needed.
Well, but I mean, the attorneys, they can either nod if they feel like it, but I think we have to do state something for the record for the basis of our determination.
Right, that it meets the bylaws for what constitutes a single or two-family home
Yeah, just the basic
residence. Yeah.
Attorney Tyne and Glover, are you okay with what you're hearing for your purposes? We just okay.
Well, I mean, for the first item, I can just say, considering that there are no limits on the number of residents in the Northampton zoning ordinance, I just
Okay.
Or a single family residence.
yeah.
Okay.
I mean, so this constitutes Northampton zoning
I would,
ordinance. Yeah. Good.
I think if you're going to say that, Nathan, you should say no limits stated.
Oh, okay.
because it's not like there's no limits. It's that
Right,
there's
right,
no
right, right,
limits
right, right.
stated.
Yeah.
Right.
No specific.
Okay.
Okay. Right. So
I
yeah,
think I seconded that.
Okay. So I guess just a roll call
yeah.
Last
vote.
hour.
So so
Again, by saying yes, we are
Declining the appeal,
okay.
denying the appeal.
denying the appeal.
Yeah, by saying yes, I'll just type that for myself saying yes. The ZBA is denying the appeal. And so the motion, just to summarize again, is by Matt Maureen. We deny the appeal by Attorney Glover of the building commissioner approval decisions for the residential mental health program in issuing the building permit, LU, or actually I will just decision for the residential mental health program via applications IDs LU25-8 and LU25-17.
I think we said with respect to applications number.
Oh, okay.
Yes, with respect to, that's helpful.
With respect to applications, I'll just remove the ID. With respect to applications LU25-8 and LU25-17. In so doing, the ZBA determined that the building commissioner did not err in his decision.
That's good. I think
Okay.
that's good.
All right. So
Roll call.
is the ready? Are you ready to make the roll call vote?
Yeah, I think so.
So yes, it's denying the appeal by Attorney Glover.
Correct. So yeah, we understand.
Okay, great. By roll call. David,
Yes.
Elizabeth,
Yes.
and Maureen.
Yes.
Yeah, that's unanimous. Did we have any minutes before we adjourn?
We did.
I just want to say I very much appreciate the input of Sherry and Aaron.
Oh, I was going to ask one question, David, really to everybody. This is complicated enough and there was enough back and forth that I'm just wondering if we should really wait to review these minutes until the next meeting. Is it possible to get them sent to us earlier?
Oh, you mean the new minutes? Yes. Yeah.
Minutes from today.
As soon as you can get us minutes from today, Nathan, it'd be appreciated.
I
Yeah,
think
like
this is-
advance. Yeah. Oh, how soon? Well, I guess we have to first decide the next meeting. But how soon from the next meeting would you like me to send it to you?
Whatever you can do. I mean,
Yeah.
I just definitely don't, want that should be a priority.
Yeah, I don't want there to be errors because this is going to go forward.
Right. And
I have not reviewed the minutes that Nathan sent us. I'm sorry.
Why don't we do that?
Admit that.
Everybody's tired. We can do those minutes at the next meeting also.
very short.
Is there a deadline on looking at those or no?
I don't think so.
No. Yeah, typically
yeah,
like
no.
one, I think within 3 meetings,
All right. So our next meeting is September 25th, right?
Yes, and actually that's part of the agenda. Would you like to so there's a new application that came in about converting a garage into a second home. It's a very short application relatively compared to the variance that's already been scheduled. So you already all did the poll, thank you, except for David. I guess the question is which state.
Next time, tell me. I thought I did it. I apologize.
Oh, okay.
But September 25th, is that the day?
Yeah, so basically September 27th is the last day where you have to open the hearing for the new application. So that means you either have to open the application on the 25th meeting, September 25th meeting, you can continue or decide on it or hear it that day, at least by September 25th, or you can have a regular earlier meeting on the September 11th. So that means the variance meeting still has to happen on the 25th of September. You can decide whether another date is suitable for this new application.
I don't think we need another date. As long as that person doesn't mind waiting through the first hearing, since that's already scheduled, we might as well do them both on the same day. I'd hate to have to come to a whole new hearing just for something that it sounds like it's not going to be that complicated.
And which day would that be? I'm confused.
September 25th.
Yeah. So in your poll you took members noted different availability. So yeah, September 25th is possible, except for Elizabeth gave a maybe for this new application. And also for September 11th, which means a whole new date, um, three members, noted availability, and same with October 9th and 23rd. But I guess really 25th is the last day to open the
Can you
hearing.
make September 25th, David?
The 11th is better for me, but is
I
the
can do the 11th and not the 25th.
Okay.
Well,
And the 25th item is one that I've recused myself from anyway, so I can't participate. I mean, I could make that other small agenda item, I suppose, but I don't know that.
we can't switch that hearing to an earlier date, right?
No, yeah, it's already once the schedule
We're
is
locked
confirmed.
in.
it
Yeah,
has
Yeah.
to be the
you're locked in.
25th.
Yeah.
So
Okay.
yeah. So the main question is for you is to decide this new application, the garage conversion, whether you want to hold it on the 26th after the variance hearing, or you want to hold it on a date such as September 11th.
So I have a problem on the 25th.
Oh.
It means missing something that would be really bad form to miss, but I had committed to the date. So, and if Maureen's recusing and Sherry can't be there,
Yeah, no, I can't be there at all. I'll
and
be on a
David,
plane.
you're
25th sounds like a problem.
Uh-oh, let me go back to our availability list. OPS.
Well, we won't have a quorum if David can't make it anyway on the 25th.
Oh, so earlier, I think members noted sufficient availability. So I understand things may have changed. So basically, in our earlier notes, let's see, so David, Elizabeth, and Aaron noted availability. I understand things changed. So, or at least earlier on
On the
before.
11th?
Yeah, for the 25th, I mean,
No,
earlier,
for
like
the
when we
25th.
did the polling earlier, for the 25th variance hearing, David and Elizabeth and Aaron noted availability. I understand if that has changed, but
Well, yeah. First of all, now I'm just confused about which. There's some other poll that I did not take. Now I'm really confused
yeah, I'll show the screen. There's a new program I'm trying when available. Um,
because I knew I
yeah,
took a poll. So that's why I
yes.
kept thinking when I saw your emails that I already did that. So in the for, next time, just suggestion: send each person who didn't answer an
Yeah,
individual email because I
right.
thought.
Yeah, yeah. Do you
But
see?
anyway,
Yeah.
the 25th. That sounds like it's well. I mean, I can. So let's see. So if I do make it the 25th, it would be me and Aaron. Is there anyone else?
Well, I said I could, but if there's any way of changing that date, I would be enormously grateful.
Me too, because I've been invited to somebody's beach house, but
And I've been
Ooh,
that's
invited
what
to a
changed.
retirement party that, is a very, very big deal.
But Elizabeth,
Yeah.
I can make it. I can make it work. But do we still need one other person? It sounds like,
Well,
or
Erin said she can be there.
but that's Aaron and me, but Maureen's recusing and Sherry's
And
not.
me. I mean, I can be there. I'm
Right.
just saying I would be very grateful if I didn't have to be.
Right. So Nathan is there, and I'm sort of in the same boat. I can do it. I just have to duck away at
Is there any way of changing that 25th to the 11th? Could you check with is that like verboten or is there any flexibility in that?
My understanding there's not because it was already opened in June just to set up continue to a date certain, and the date certain was 5:30 at September 25th. So we may be able to I mean, reopen just. I mean, if there isn't a quorum, it cannot happen. Another possibility is using the Mullen rule. So Mullen rule basically means you can miss one deliberation meeting and but watch all the relevant recordings and then continue it, make a decision. So if you don't have a full quorum, the member who missed the first deliberation, they can watch the video and all the materials and then
oh my God.
yeah.
But wait a
Sorry.
minute, Nathan, I'm not understanding why
Yeah.
if we're going to move it earlier than the 25th, that would be a problem. I know we set the date, but if the parties are amenable to moving it up, it's within the deadlines. why are we stuck with a rigid date?
I might be wrong, but my understanding is once you set up a day certain for a hearing, you can open it and delay, continue it, but you cannot pull it earlier. You cannot reschedule or already scheduled hearing to happen
Right,
earlier.
so we could not
Could we
have a quorum
continue it on the
and
25th
yeah, and so not show up,
or
not,
show up for 5 minutes?
Yeah, and the one of the complicated details whether there are certain deadlines. I'm trying to figure out the timelines. So after you open the hearing, you have to make a decision within a certain time period. I believe it's 90 days. So because it was opened on the 26th of June, we got, I think, 90 days to render a decision from June 26th about the variance. I'm talking the variance. So 90
can't be
day.
waived, that 90 days can't be waived by agreement of the parties?
Yes, you can.
Yeah.
Yes, yes. Then would you like me to, well, first of all, then, yeah, why don't, would the board, it seems like, deliberating on the 25th of September will be difficult for many board members. So how about what if you suggest a certain date and we can get the applicant's agreement, to continue to another date,
Right, the next one would be
October 9th?
October 9th.
Yeah,
But that's beyond the
No, they'd have to agree.
yeah, yeah.
We're saying we could propose to them. We say we're going to have a problem having a quorum. Would they agree to continue to?
I could be there on October 9th, so
Yeah,
that's
me
one
too.
person.
And a really rarely used option that's possible is you hold a special meeting outside the regularly scheduled slot. But
Well,
Nathan, did
yeah.
I also read something? I just recently
Yeah.
went through the non-disclosure training again. And was there something that had to do with there's a Latin word for it, but if I recused myself because of potential or more accurately perceived conflict of interest. Like if I disclosed that, could I participate?
There are definitely scenarios where if you disclose and no parties object, you can participate.
I think you're appointing authority as a mayor, so you have to get a written approval. If
Oh,
you, yeah,
right. Yeah,
yeah,
that's what,
yeah,
yeah, I would have to actually put something in writing.
yeah.
Yeah.
And the
I,
mayor has to determine
okay.
that it's not like a sufficient conflict of interest. So you have to
Okay.
wait for a decision. So either you recuse or if you want to participate. And of course, again, this is sort of the
Probably not
question.
helpful.
Yeah, or you
Yeah.
can participate as a general member of the public, as a building inspector has done earlier.
Yeah. Yeah.
So
Okay. I think
yeah,
I'll take that off the table. I think
okay.
it's probably
So
the
maybe
least of our options.
Nathan, can you explain that we may have a problem with the quorum? Would the parties
Mm-hmm.
mutually agree to a continuance to
Yeah,
October 9th?
yeah.
And
For
if for some reason they won't, I mean, I can just find a quiet place. It's too bad it's a variance though, because
yeah, that's the problem. It's going to be.
it's not like an additional sign.
So that other one, Nathan, can that be put on October 9th or is that too late? Does it have to be September 11th then?
Uh, I mean, just if there are two members, so you have to at least open it. You have to at least open it with two members sufficient, and then you have to continue. Basically, the opening day for that new one is the deadline is September 27th, practically September 25th. So
So
you
we
have
could
to at
do
least
that the
open it.
11th, right?
Hmm?
We could do that one the
Yeah,
11th.
yeah, you can listen. Yeah, because it came in. Yeah, so obviously I spoke with the applicant about the later scheduling, and like any applicants, the applicant was not super happy. Everybody wants as soon as possible, obviously.
Yeah, no,
Nathan, are you absolutely certain that with their permission, we can't move it to September 11th?
You know, it's the, I think my understanding of the principle is that because the public has been notified about a certain date, you
right,
know,
because any members of the public
Got it.
would
Yeah.
who would want to know
Excuse me.
wouldn't know because
They
because
wouldn't know it was moved.
said something at that
Yeah.
last meeting.
Yeah,
It's,
yeah, yeah.
yeah, it's for the public benefit, from my understanding, because
Right.
they cannot travel
Makes
forward in
sense.
time.
So,
Delay is knowable, but not advanced. Yeah.
okay, in the interest of let's getting out of
Yeah.
here,
Yeah.
we'll
Yeah.
schedule that garage conversion for September 11th.
Okay.
Okay. Oh, I
Right.
mean, October or September. Oh, September 11th.
September
Okay.
11th, so we're within
September
plenty
11th.
of time. Why do I have a hand thing? I didn't do that. There's this
Yeah.
floating thing. I'm
Thumbs
just
up.
sitting here and all of a sudden there's something floating. And then September 25th, you're gonna try to talk to them. Just tell them we don't have a quorum and that we need to postpone that till October 9th.
Yeah.
Right?
Continue it.
Yeah.
And
Yeah,
if and if for some reason they absolutely will not agree, because I realize time is money for people trying to develop.
Right, right. And this is from June.
And I mean,
Yeah.
I can be available, but I don't know.
I'd like to just say there's not a quorum and
Yeah.
Yeah, definitely try that. Start with theirs because it's true.
Yeah. We will not.
it
Yeah.
is
We'll
true.
not have quorum. So, yeah, to the attorney for the variance, we will
This
not
happens
have
in a
a
lot of
quorum.
towns.
Unless Aaron, you want to do that whole hearing all by yourself for the, I'm only kidding.
I don't think I qualify as quorum.
Or
Yeah.
the other option is one of Nathan's options was to schedule a special date.
Well, let's see if this works first. And
Yeah.
then
Yeah.
Yes,
So,
yeah.
yeah,
We'll
October.
revisit that if this doesn't work.
And yeah, if this is in writing, basically, if for September 25th, if nothing's gonna be happening, nobody needs to attend. The writing basically allows you to just, just attend the ninth one. So yeah, back to garage conversion, just to double check. We need 3 members for the garage conversion hearing too,
I can be
because,
there on the 11th.
okay,
I
so,
can be on the 11th.
This
Elizabeth,
is September 11th.
yeah,
Yeah.
Let me make sure I wrote it down in the right place.
Sherry,
Yeah, I can. Looks like I can be there.
okay, and what about the other members?
What did I put in the survey?
Oh, yeah,
I'm a yes.
so people who say yes for the survey on September 11th, that's Maureen, Sherry, and Aaron.
Okay,
That means I can.
you can add me.
Okay, so Maureen, Sherry, Aaron, and David,
and Elizabeth.
and yeah, and Elizabeth, you earlier said you were not available.
I know we're
Yeah.
actually not leaving town until the 15th, so I wasn't sure. So I'm here on the
So
11th.
it seems like we'll have all the members available, all 5. So Elizabeth, Sherry, David, Maureen, Aaron. Okay, for September 11th, I know that all members are available, which gives a lot of room. Okay, thank you. And for the North Farms variance, I'm gonna email the attorney and ask to continue to October 9th due to quorum issues.
See what they say, and if it's a problem, maybe we try to find a special date.
Yeah. Yeah.
Although I don't know what the notice requirements are for a special date, but
I
guess we would announce it on the 25th.
Yeah.
If anyone shows up, somebody would announce it on the 25th.
And I think if the date's certain, I mean, I think it depends on whether they agree in writing or not. But if they want another date, we can. And coordinating dates is not an issue with open meeting law. But we'll get there when we'll deal with that if we get there. I'm hoping the
Give
attorney
yourself some trouble, Nathan.
And we would just need 2 people to show up on the 25th to continue it to a special date. Well, actually, we have to do that to continue it to the 11th, probably.
That would be a 5-minute meeting.
Well, we'll
The 11th is the garage conversion.
I meant the 25th. We'd have to have 2 people show up on the 25th to continue that one until
October 9th.
Till, whatever the next date was, or any other special date.
Right.
I mean, I think if they are agreeable in writing, the writing basically I can just be there and tell people, hey, we're continuing to this
Oh,
date
really? Okay.
based on writing. Yeah, I think the writing. Also, some people recommend at least 2 members being in person to announce that. My understanding is writing allows
I could do that. I mean, that took when Aaron and I did it a few weeks ago. It took 3 minutes.
So and again, I think I'll work out these details.
And can we deal with today's minutes next time?
Yeah, I think we've agreed to that because we're burned out.
So motion to adjourn. Are we ready for that?
I think so.
Oh, we are. I
Okay.
move to adjourn.
All right. Okay.
Second.
Okay. That's Maureen. I'm just noting the time. I really thank you and apologize for the long
I'll second
time.
that. Louis, really
Okay.
great to see you. Thank you for coming.
And Elizabeth.
Yes.
Okay.
Second.
So I'm just gonna take roll call for the first three members. All right. By roll call. David.
Yes, in favor.
Elizabeth
Yes.
and Maureen.
Yes.
Thank you so
Um,
much. And
Great job tonight, David in
Oh
particular.
my God.
Everybody.
I'm
Thank
gonna
you.
stop recording.